development options, conditional contracts, and overage provisions. And I was saying to Catherine just now, I mean, I absolutely love doing property development work, and it's of all the things I've done in my long career, it's the one that has given me the most intellectual satisfaction. Although most of the financial rewards go to the clients, and you just get long nights of worry and weekends, etc. And the reason I liked it so much is because it isn't routine, and people coming into this from, say, a residential background are just assuming that everybody is on the same side and we're all working together for the same thing and that sort of thing. Whereas with commercial work, and particularly with property development work, it's very much a combination of something like Sherlock Holmes and Game of Thrones, because people are busy trying to outwit each other and try and get one over on each other and sell you something which is actually not very good. So being a combination of secondhand car sales, Game of Thrones, and Sherlock Holmes. And the usual weapons that are used are either options, conditional contracts, land promotion agreements, and sometimes overage agreements. And sometimes it's a straightforward purchase of one parcel of land, and sometimes it's what's called a site assembly. I haven't managed to ask each of you what you each do, but some of you may be new to this. Some of you may have various levels of experience, but I'm pitching this webinar on the basis that you're basically starting from the ground up and you want to get into it. If you are in that situation, and in fact, if you're dealing with commercial property at all, the single best book you can buy to help you on commercial property and anything to do with development is Gavin Leshat's excellent book, Property Development, which is about 100 odd quid from the Law Society's bookshop. And in fact, even if you're not doing property development work, I think anyone dealing with any kind of property work, particularly anything with a commercial bent, ought to read the first 100 pages, because they are an excellent intro into things like Section 106 agreements, easements, rights, restrictive covenants, etc., 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 and what the searches are. So if you've got someone in your department, or you're new to the department that wants to start dealing with something other than resi, get that book and read the first 100 pages. The rest of it deals with the property development transactions, and there are an excellent set of precedents at the back in a CD-ROM, which go beyond just standard documents, but also draft letters to different types of authority, different types of report, and so on. So it is a welcome addition to anybody's library. And yes, not everything is a practical law. Practical law is excellent, but comparing it with proper textbooks is like comparing, being a first aider to being a hospital consultant. It's good at a certain level, but it rapidly runs out of steam when you get to something complicated, and there is no substitute for the respected textbooks on the different things. I should have mentioned at the outset, I'm going to stop and have a lie down, or for you rather than me, every hour or so, because I do think that when you're watching something on a screen, it is fairly intense, and it's better to have a break. So the first thing I'd just like to mention is the auction. Now, some of you may have been involved in auctions, buying or selling, and they are a minefield for people who have not been used to that. And the worst thing of all is the usual sort of ordinary developer is usually somebody who's, I don't know, a bricklayer or an electrician who's made good, and he wants to get into property development, and he rather looks dismissively at all this paperwork that us lawyers have to do, and he assumes that he has consumer rights and that somebody has obliged to tell him things, and that surely he can't be at fault, and surely he can't be made to buy something which isn't okay. So he wanders along to an auction and he looks through the auction pack. He doesn't understand any of it, and he thinks, oh, that looks a good one. Oh, reserve price is low. And he wanders along and he sticks his hand up, and other people may stick their hand up and it gets knocked down to him. And he comes along to you and says, oh, there you are, I got this. I mean, like a client of mine, he was a really, he was experienced, and I couldn't believe what he'd done. He put his hand up at an auction and bought something for £200,000. And I said, why don't you get me to look at it? Oh, well, it's straightforward, isn't it, mate? And then go on a couple of years and he's bankrupt as a result of that. And he lost all his property empire and everything else because he didn't know what he was buying, and it turned out it was going to cost £1.5 million to lay drainage into it, and he couldn't use any other way of draining it. He spent all that money and he still couldn't develop it, and that brought everything down. And of course, if you're the sort of solicitor who is behest to a client who says, "Oh, I'm bidding for this at the auction, mate. Can you just have a quick flick through the auction pack and tell me it's okay?" And a lot of clients will do that because they think we're just doing procedural work. And you'll have a quick look through the auction pack and you think to yourself, "Oh, I'm not getting paid anything for this. I'm doing it on spec. So, I just, oh, yeah, looks all right. Looks all right. Oh, what's that? Oh, there's an email. Oh, yeah. Yeah, it looks all right, Fred." And then Fred bids for it. And then you discover when you actually get the papers that it's an absolute can of worms. Then he's going to say to you, "Well, you told me it was all right." And you'll say, "Well, you didn't pay me for it." But unfortunately, even though you didn't get paid, you've still got the full liability and negligence as if you've done a full investigation of the property. So you have to say to clients, look, auctions are a minefield. There's usually a good reason why something is being put up to an auction. If it's being sold by a public authority or local authority, then they sell things at auctions because they have an obligation to get the best price reasonably obtainable under Section 123 of the Local Government Act 1972. And the valuers or the estate managers don't want to be liable for arguing that they undersold a property. So they will stick it into an auction to say, "Well, I put it up to auction, it got a good price, and therefore I'm okay, Jack," etc. But any other situation, if there's any decent piece of development land that is being sold by auction, you have to ask yourself, why is it going to auction? Because if it was a decent piece of development land, then rather than the uncertainty of an auction, the agent would have put it through his trusted confidants that are always slipping him a few quid for putting good sites in their way. And this sort of thing does happen. One client said, "I'll give you £25,000 cash into an account of your choosing if you just let me know if there's any probate sales that come through or any decent things, and you push them my way." I mean, you can't do that. But in the wild west of property development, they all think that seems fair and reasonable. So this sort of thing has happened a lot. And in the footnote to my notes there, you'll see worth a click on a Daily Mail article that I was told about by a solicitor who acted on the sale of the property to a mad lady from London who bid for a property which seemed really cheap and paid £170,000 for it on an auction online, never visited it, no inspection, nothing at all, and then realised once the gavel had fallen that it was about to fall down a cliff and refused to pay for it and got sued and taken to court and made to pay for it, and felt that it wasn't fair. Surely they should have told you, surely, etc. Surely. But unfortunately, there is no surely in it. You have no consumer rights. There was a recent case which astonished me that something like an overage provision that we'll talk about later was held to be a latent defect and needs to be mentioned in the auction. Otherwise, the buyer could get out of it. But pretty much every other situation, once the hammer falls, it's yours, and it's usually a can of worms. The other thing to be aware of on auctions is that you may have navigated your way around the commercial property standard conditions, which are different from the normal conditions of sale because they have additional features that are relevant to, in particular, leasehold transactions. But the RICS common auction conditions are the usual conditions you will use for an auction, and they are much better in actual fact than the Law Society's ones, and they're not shrouded in copyright. You can download them from the RICS website. They're easy to read. They have a glossary. They're well set out. They're well worded. They're not crammed into 6-point text on 2 sides of paper. And they contain lots of clauses in there that ought to be in the Law Society's conditions. But because the copyright is owned jointly by OEAs, OEAs won't agree, because if you put more conditions in, it would go more than 2 pages. And that's more important to them than having decent set of conditions. So do realize that there may be additional conditions, and even including an environmental indemnity that you might unwittingly be given if you bid for something at auction. But auctions, if you ever get a chance, do go along to them, and they are, it is just like you get everybody, you get all sorts of people, especially one of the London auctions, and they're all as rich as anything, and they could, buy and sell you, and they're all putting their hands up and bidding for things, often blind. And some of them will make money and some of them will make nothing at all. So that's just a little bit of an intro And what you're more likely to come across is going to be either an option or a conditional contract. Now, these are often bandied about as being the same, but they aren't. And it's an important thing to realize, particularly when you are advising an innocent, say, landowner who has got a builder saying, oh, I want to take an option on your back garden or your field or something of that nature. And the builder will unfortunately not be particularly scrupulous. And I even acted for one of the best developers I ever knew. He was so clever. Nobody ever got one on him, and he was about the only one that didn't go bust in the recession in 2008 or whatever it was. Anyway, he even had me draft a 2-page document, which made it look like it was something he cooked up himself, but had all the right words in. And he produced it himself, and he went around to people saying, oh, you don't want to bother with solicitors, mate. You know, it's easy, and just sign this and it will be fine. You don't, you know, it's just a waste of time going to solicitors. And people would sign it, and they were completely stitched up because I'd made sure that they were completely stitched up. I know there will be a special place in hell reserved for me as a result, but, you know, that's what the client wanted me to do. So sometimes that will happen, and it may be that the builder genuinely wants to buy the land, or it may be that the builder, as in this developer often did, was just locking out the land so that nobody else could develop it because he already had options on 3 other sites, and he wanted to make sure that he could choose in this particular town or village that he would be the one that was running the show in relation to development when things came forward for development in due course. So what you often get is people coming to see you who've signed an option agreement to a builder without any legal advice whatsoever, and they don't realize that there is no guarantee at all that they will ever make any money, because the option is what it says. It is an option that the builder can operate if they want, but they don't have to. So if you've given someone like a builder a 5-year option or a 4-year option, the result of it is you cannot, in effect, sell your house, garden, or field so long as that option is in existence. And people don't realize that. Perhaps they need to sell the house because they're getting divorced, or one of them, a joint owners, dies, or something of that nature. And nobody's going to buy a piece of land that is subject to an option, because they not only will probably find that the land is then taken off them by a builder and it's out of their control. So what you have to say to clients is, look, do you realize what this option is? There is no guarantee you will ever get any money whatsoever. The only guarantee is that you will not be able to deal with this land for a couple of years without the builder releasing the option. And he's not likely to do that because he'll have probably spent a lot of money on planning consultants trying to promote this particular site, and he doesn't want to lose all that potential money. And the price that you get paid on an option is not normally a fixed price. Normally, it depends upon the increase in value as a result of whatever planning permission the developer gets. And there will be usually some sort of, in principle, agreement in the heads of terms, if it's negotiated between agents, that the developer will get some sort of discount for on the market value to reflect the amount of money that the builder has had to spend on consultants, and possibly also the costs of putting in infrastructure, drainage, access roads, improvements, and so on. So not only will the developer want to be able to deduct those sort of costs, they will often also see if they can negotiate an overall reduction on the price to reflect the uncertainty and the money that they're putting out there on the hope that this is going to be developed. And again, this could be, say, as much as 50% of whatever the uplift in value will be as a result of getting their planning permission. But then again, if you think about it, if you're going to have to work out the market value of the land and then knock off 50% and then knock off all of the infrastructure or development or planning consultants' costs, then the seller may not be getting such a good deal as they think after all. These days, perhaps the increase in value from say, agricultural land at 20,000 an acre to residential development land at anything, say, £750,000 an acre or more, can seem quite substantial, and it will be a lot of money for the seller. But of course, you have to make them realize that it isn't going to be straight off the top, that there may be negotiations, and there may in fact be an element of double counting. The developer asking for a discount of 50% on the basis that he's got to spend all this money on infrastructure or improvements or consultants, and then getting the money back on top. So at a heads of terms principles idea, how is it worked out? When does the deduction take place? And we'll talk about the weapons of math destruction later on. And the many problems I've seen where developers or sellers exploit each other unwittingly, and then there are arguments afterwards with the relevant parties' solicitors over whether they picked that up, because everyone wants to assume that their solicitor has to, or their licensed conveyancer or their legal executive has to take the blame for anything that didn't go according to plan. So options are generally called call options. You don't rarely ever come across a put option. Just by way of explanation, a call option is where you give me an option on your land and I can call for you to sell it to me. Whereas if you gave me a put option, that would mean sorry, I'll start again. If it's a call option, I'm the builder. You say, I'm going to give you an option to buy my land if these things happen in 2 years' time or something of that nature. If there was a put option in place, you would say to me, the builder, I am going to agree with you that you will agree that you will buy my land whenever I want you to. And that's why I can put the land to me, but they're very, very rare in practice. So normally call option is what people mean when they talk about an option agreement. And you'll often get these sort of deals negotiated between land agents, clients direct, or respective land agents, and there will be a heads of terms which will be sent to you to document the transaction. And you have to look at these heads of terms very carefully at the outset, because sometimes the agents are not really up to speed on these things and they don't realize tricks that they may have missed. So a couple of points on the top of page 2 there, the sort of things that you need to think about, and we'll go through lots of other things later on. How much is there going to be an option fee? You know, so I'm giving you, the builder, an option on my land, which means that I can't sell my land for another 5 years or 2 years, and I won't be able to, you know, there won't be any liquidity in it, even if I need to sell it for, I don't know, medical expenses or divorce or death or something, it will not be possible. So am I going to get any fee to compensate me for that? And normally builders will not want to pay anything at all, or they'll want to pay £1,000 or something of that nature. And the cynical developer I talked about before, he cunningly said, well, what I do is I work out how much money it would cost to send the seller and their family to Disneyland in America. And I say, I'll give you £7,000. And that will pay for a trip to Disneyland for you and your family. And they all go, oh, that's good. That sounds like a good idea. So cynically, that's the sort of thing that goes on. So is it going to be an option fee? Is it going to be, perhaps if the option is extended every 2 years, is it going to be an additional fee? And is that option fee going to form part of the ultimate purchase price when you get it? Or is it going to be a genuine compensation for the lack of the seller's ability to sell it? The next thing is, how long is the option period going to be? Now, most planning agreements, and we'll talk about them later, will take a couple of years to negotiate. So you'd want normally a 2 to 3 year option period initially. Then the next thing is, how are these notices going to be served? When is it going to be exercised? And normally you will have something so that the notice to buy it can't be served until such time as there is a planning permission issued. Because otherwise, if you think about it, if your piece of land is worth 20,000 and with planning permission it's worth £1 million, and the option agreement simply says, on service of the option notice, a valuer will be appointed to assess the value of the land, okay, and then you will sell it to me for that price. Then if I'm a builder, I might think, well, you've signed the option agreement, I might wait a decent interval, and before I've made any planning application, I'll just buy it for 20,000 an acre. And then I know, because I've talked to my valuers and the local authority, that it will go up in price to 1 million because it's going to go through without any problem. So rather than waiting for the planning permission to be granted, I'll serve the option notice before it's granted, once I know it's going along quite nicely, and then I'll get it for 20,000 an acre. And when planning permission is granted, I won't have to pay you any extra money. So it may be that there is a precondition to the exercise of the option, such as the issue of a planning permission. And then the next thing is the point of principle of how the final price is going to be worked out, and whether there's going to be any kind of discount in percentage terms, or for deduction of the costs of infrastructure and so on that I mentioned. And if you haven't dealt with these sort of valuation issues, then do look at Gavin Lashat's book and talk to colleagues who have, because I have seen in many, many, many years looking at option agreements and conditional contracts for banks who are lending on development agreements, as well as developers and also selling to developers, that you can often see situations where people have missed something out and one party or the other takes advantage of the other, and that party then complains to their solicitor that they didn't pick this up, etc. So it's, as I say, Game of Thrones strokes chess stroke Sherlock Holmes. So it may well be that if you're a seller, you might say, no, I've spoken to my lawyer about this, and I'm not going to give you an option agreement for all the reasons I've mentioned, but what I will give you is a conditional contract. And just to explain the very subtle but important difference, with a conditional contract, it isn't entirely up to the builder whether or not he buys the land. So the conditional contract, as we'll look at later, will often force the builder to make an application for planning permission. So he can't just sit on it for 2 years and then say, I've changed my mind, I'm not going to do anything, whereupon the seller is then got to go back to square one and find someone else, 2 years down the road, and he's got to start another 2 years. With a conditional contract, the seller will impose an obligation on the buyer to make a planning application, and we'll look later about how detailed the seller's control may be over that planning application. And then the seller knows that they've got a good chance of this going through within the timescale they want, and that they will get money, because when the planning permission is granted, then the builder must buy it. They don't have an option, they must buy it. And at that stage, a formal contract is created. The unconditional conditional contract becomes, the conditional contract becomes unconditional, and the builder must go through the process of assessing the price and buying it. So of course, from the builder's point of view, he's got to realize that he's got to put his money where his mouth is, and he will be called to pay for this at the end of the day. So he's got to make sure that he's got the funding available to pay for it at the end. And often that's where I got brought in, funding these transactions where planning permission has been granted and acting for a bank, and you may be acting for a bank. You have to check that nobody's missed something, and that this piece of land, although it's got planning permission, may have a defect, and it may not be capable of being implemented to this planning permission, and that it is going to be worth the money to lend money on and possibly finance the developer in order to build out the property and obviously make a profit at the end of the day. So as you can see, it is an absolutely fascinating and dangerous area of work that is brilliant if you can get into it. And don't worry about it, because you can learn from other people's mistakes by reading Gavin Lashat's book, looking at the precedents, reading practical law, listening to me, and talking to the clients and managing their expectations on this. I've just got a reminder from Catherine to say the chat function is there. If you've got anything else in there, I should notice a little red dot, and I should have a look at it if there's anything you want me to explain at any point. So hopefully that has whetted your appetite, or terrified you, or a mixture of both. And we'll now have a look at some of the general issues. Now, let's say, now I've given you the sort of intro. We've got options, we've got conditional contracts. What are land promotion agreements? Okay. Now you can see that there's, it's like war between buyers and sellers. The buyer's trying to get as much as off at the price and trying to trip up the seller, and the seller's trying to make sure that the builder doesn't catch him out. So there's a lot of animosity and aggression and sort of chess moves, etc. Wouldn't it be nice if there was a way in which people could work on the same side so that their objectives were working together on that? That's the idea of a land promotion agreement, which has become very popular in the last 5 or 10 years because it avoids all this sort of warfare and so on. So what happens with a land promotion agreement is the builder and the seller of the land says, let's work together on this. Let's agree on what we're going to apply for planning permission for before the builder does it. And that, in fact, what the builder is going to do is going to be more of a developer than a builder. He's not going to build the land himself. He's just going to get the planning permission, which increases the value. And instead of the developer building it, he will then sell it on to a builder, house builder or someone else, and then he will get paid when it's sold for all the costs and expenses that he's incurred in promoting the site, and he'll get a fee calculated as a percentage of the profit. So whereas with a conditional contract or option agreement, the builder's trying to build in as many deductions as possible so that the seller gets as little as possible and he has to pay as little as possible, the builder, or the developer, I should call him the developer is motivated to maximize the amount of profit that will be made on the sale of the land. So it's in his interest to get the best planning permission possible. It's in his interest to keep the costs of getting that planning permission and infrastructure costs as low as possible, because they're both sharing the same interest to flog it for the most profit possible so they can share the spoils, and the builder might get 25%. Although the builder, it is a fee, will charge the seller VAT, and that's beyond the scope of this course. The seller may have to think about how he's able to recover that VAT in due course. But usually a land promotion agreement is going to create less animosity and more working together. But whereas you might have a farmer who's selling a piece of land on a conditional contract or an option agreement, who doesn't have the first idea about, what is a good planning permission, what is this, that, and the other, and they just rely on the builder to do all that because the builder's got their professional team who knows all this stuff. The farmer is going to have to sit down with the builder, or the farmers are going to have to appoint consultants or advisors or planning people, which he will have to pay for, whereas he wouldn't have to do that on an option agreement or conditional contract. And there'll have to be lots and lots of meetings where they both sit down and agree what's going to be applied for, who's going to be the buyer, how much is going to be paid for, who are the consultants. So it's more of a partnership agreement or a roadmap, as we'll look at later, than an agreement where the seller just sits back and waits for the money to roll in, hopefully in a couple of years, and the builder does all the work. Now, does anyone have any questions on that? But it's absolutely vital that you understand the differences between options, conditional contracts, and land promotion agreements in concept. Right, that's that. Next one, what is an overage agreement? Right, now this is something which is sometimes called clawback. When you're acting for a local authority, they're terrified that they'll have found that they've sold something too cheap. And there are many, many examples of local authorities selling land too cheap, and then a builder changing use, getting planning permission, and then making lots of money. And everyone then gets criticised at the council, and they will therefore often insist that when they sell a piece of land, there is something called clawback, that if the use is changed or it's developed in any way, it may be that they've sold a piece of open space or a field or a rugby ground to a developer or to someone, and then they sell it to a developer, and the developer makes £1 million, and then everyone wants to fire the chief executive for missing out on getting that money. So in that situation, if there was a change of use or increase in the land or development on, then the council will insist on getting some of that profit as clawback. But you can use the words overage and clawback interchangeably. So there are lots and lots of different ways in which you can structure transactions. It's important to think of all this at the outset. You may have a conditional contract or an option agreement, or a land promotion agreement, which also has overage in it as well. I mean, to give you an example of that, I saw a recent case where a builder bought a piece of land from council on a conditional contract, And the basis was that it would be 30 was it? No, it was 300 houses were going to be built. So the council got a lot of money for it. Fair's fair. But then the builder, after it got the land and paid the extra money, then made various variations on the planning commission over the next 3 or 4 years, and they finally got 600 houses on the land, therefore selling it for a lot more money in plots than they would have done with 300 houses. And of course there was uproar because the council wasn't seeing any of that money. But if they put an overage provision in there, that would mean that each time there was some sort of change, like an intensification of the use of the land or a change in the planning commission or something of that nature, there would then need to be a revaluation of the price that had been paid, and that the builder would have to, or the developer would have to spend, give the seller more money. So overage is something that we'll look at in the second half of this course, but it's important to see that it's going to be, it's going to occur in a lot of documents. Thing I found endlessly, sorry if I sound like a cynical old git, but the number of times I get heads of terms from agents and they negotiate all the things about the price and everything like that really well, and then the final clause say overage. There will be 50% overage on the usual terms, and ring them up and say, "Yes, Steve, it's Hannah here. Can you send me a copy of these usual terms? Because I've been doing this for about 20 years and I've never seen them. Isn't that strange?" And they go, well, yeah, you lawyers can sort that out. And it's basically because they haven't got a clue, and they don't want to admit that they haven't got a clue, and they just want to fob it off, and they don't realize how important it is. So sometimes you have to either say to them, no. If you haven't got a clue what you're doing, be honest about it, and I'll give you some ideas. But before anyone starts drafting any documents, we've got to understand what this overage is, how it's going to be calculated, when it's going to be payable, and all this sort of thing. Because there's so many times, that I'll talk about later, that people just rush out a document because they get something off Practical and print it off, and it's complete garbage. And you then have to spend even more time going back and saying, no, this isn't what we had in mind, and it holds everything up. So it's important to get things agreed at the outset in the heads of terms before anyone starts drafting documents, because it only means that people get entrenched in ideas, resistant to changing, and really holds it up, and lots of egos get sort of in the way of negotiating a good deal. Okay, so few lightning run through options, conditional contracts, and land promotion agreements. And you're probably thinking, "Ooh, I wish I just decided to do probate. That would be so much easier." Now, there are some points to look at next on page 4, which apply generally. Sorry, I should have changed the slide before. Which really apply to both options and conditional contracts. So I don't want to repeat them all again when we go into conditional contracts. So some of these will apply for option agreements, some of these will apply for conditional contracts too, and some of them won't apply for options depending upon the structure of the transaction. So the first sort of thing that you need to think about generally is, what is this planning permission of which we speak here, and who's going to apply for it? It's possible that it is an option, fixed price option. You will pay £2 million when you want to, and you've got 2 years to decide it. And the builder can then decide whether he's going to get a planning permission or not. And there's nothing in there. It's a fixed price option, £2 million. You may not have to talk about it because really the price is set. But that's very unusual, and it's usually very unwise for a seller to give a fixed price option, because the builder's probably got something up his sleeve and he knows he's going to rip off the seller. So normally there will be a price depending upon a planning permission. So the next thing you've got to think about is, how would a devious developer exploit the seller? And I've seen it happen many times, where you have a very simple document that says the builder will apply for a planning permission for residential development, or the builder may apply, there may be no compulsion on the builder to do this, for a planning permission for residential development, and the price being sold will be the price of the land increased by residential development. That sounds nice and easy, doesn't it? What's wrong with that then? Well, in one case, I remember, I was acting for the bank, the builder just applied for 4 houses. What's wrong with that? Well, the site could easily take 50. But that triggered the possibility of applying, submitting the option notice. And of course the seller goes, but you said you were going to apply for 50. Well, no, that's not what I said. The document says planning permission for residential development. This is a planning permission for residential development. I want to buy it. 4 houses, it's worth £500,000. We're not going to pay it, right? We'll take you to the High Court. You know, you can have it easy or you can have it hard, but you're going to have to pay for it. You're going to have to sell it for whatever is the price. So lots of negotiations and posturing, and eventually the seller had to agree that he had to pay. The builder only had to pay what the value was with 4 houses on it. Of course, once the builder buys it, what does he do? Ka-ching! He puts an application for 50 houses, increases the value massively, and the seller gets nothing, but does get the opportunity of suing his solicitor for negligence for not thinking of this. So that's the risk of people dealing with these things who aren't aware of the machinations and Machiavellian things that builders will do. If that had overage on it too, then it may have been okay, because each time when the builder put an application in for 50 houses, ka-ching, there would be an uplift, ka-ching, there'd be more money to the seller. But the solicitor acting for the seller had not really picked up that possibility there. So that's why the seller may have to approve any application that the builder makes, or it may say that the builder must make an application for not less than so many houses or so many thousand square feet of commercial or something of that nature, or a range of different options. And it may be coupled with an overage provision to catch that as well. You can start to see how you've got to be thinking what the next move ahead is when you're drafting or approving these things. And in some cases, if you're buying from a local authority, they may have a development brief that your application has to be in accordance with, or it may be that there is even a draft application that the builder agrees to submit within the next 3 weeks or 3 months or something of that nature. It may be worked up. Or it may be that the seller simply has to approve the application that's going to be submitted. Or there may be absolutely nothing at all, and it may be entirely up to the builder. But of course, then there are risks. And if you haven't got overage in there, then you may be setting yourself up for a very expensive fall there. So do talk to your buyer, and if you're acting with the buyer, and the seller, if you're acting for the seller, what is in mind so that you can forestall these sort of dodgy things going on there. Okay, it may be that it is a simple option, it may be a complicated one. Now, as often happens, the builder might put the application in and the council may say, well, yeah, in principle, we don't really mind, but we don't really like this particular type of house. We don't like this particular type of this, that, and the other. Would you like to amend it? And of course, the builder may need to get the approval of the seller. Now, this applies to conditional contracts as well. Does the seller need to approve any variations or resubmissions that are made? I remember acting for a well-known house builder who had taken a conditional contract on a piece of land, and it was before I dealt with it, and previous Fiona had dealt with it. There's nothing wrong with what they did, but the builder had just got the conditional contract and then just stuck it in a drawer. They went along to the council and said, we'd like to apply for this. And the councillor said, no, we're never going to give you that. But we would agree flats. We wouldn't agree houses, or whichever way it was round. So they didn't go back to the seller and get approval of that resubmission. So the words of the documentation said that in order to trigger the conditional contract becoming unconditional, it had to be an approved planning permission. So the seller had never approved the planning permission, so they weren't in a position to trigger the conditional contract. But they'd got planning permission, which had increased the value of the site massively. And so I said to them, well, look, if I was acting for the seller, knowing that you've only got 3 months to this conditional contract ends, I would politely write back and say, thank you very much for your notice of unconditionality. This is not a valid notice. We didn't approve this application, therefore you can't buy the land. But thank you very much indeed for increasing the value of our land by £1 million. We're going to say tatty bye to you in 3 months' time, and then we'll flog it to somebody else, and we'll flog it for the full market value rather than the 50% of market value. And sorry, but you're basically going to have to whistle for all the money you've spent on consultants and planning applications and all the rest, because we've got all that for free. So I said to them, well, look, I'll serve the notice, be warned, and they may pick, don't ever mention this or do not discuss this with anybody, but just keep quiet and see what happens. And I can't guarantee you're going to get this land until the day we actually complete it. And then on the day of completion, we got the money and said, great, they never picked up the point. They didn't realize it. The seller obviously, oh, look, I'm getting a lot of money. They didn't think, hang on a minute, I could have made a hell of a lot more money by saying that's not a valid condition. So warn clients that if these documents are entered into, they need to be understood, they need to be read, they are working documents and not stuck in a drawer. And when any action is taken, applications, they need to come back to you and they will have to pay you fees for doing that. That's how it works. And it is better that than they spend a lot of money and then find that they've been completely outclassed by the, or sideswiped or something by the seller by not realizing that. But the cost of getting this wrong could cost hundreds of thousands or millions, and the cost of litigation is not to be underestimated. So the next thing is the builder puts the application in, and then the council say, don't like it really, sorry, we're going to refuse it. What? The builder says, well, if you do refuse it, we won't be able to build. And the council says, well, it's fine by us, we don't care. Seller says, hang on a minute, what's going on? I want you to appeal against that builder, because I reckon if you took the council to a planning appeal, you'd win. Well, does the seller have the right to make the builder make an application for a planning appeal? You see, the builder may say, well, I don't want to throw any good money after bad. I've got another site on the books, which I'd rather deal with that. So the seller is then left high and dry, and then they have to find another builder. And the other builders will obviously have to spend money and time on working out a deal. They won't be able to use the old drawings. And it may be that the original builder had got quite a long way, but because the original seller hasn't got copyright in the drawings and hasn't got any contractual arrangement, whoever the planning consultant is, they've got to start all over again. So it may be that the seller wants to say that the builder must appeal against any refusal. And the seller will think, well, I'm getting a free ride on this. Why shouldn't I insist? It's not going to cost me any money. It'll just cost the builder. So I don't care. And on the other side of the coin, the builder will think, well, I'm not going to be forced to make a planning appeal when I know, talking to my planning consultant, that it's a dead duck. So where are we going to get a compromise on that? Well, the usual compromise you get is that if the builder is going to accept an obligation in the conditional contract or option agreement to appear against any refusal, that the builder, I'm going to sneeze in a minute, will be entitled to resist or refuse any obligation to appeal if their planning barrister can show that there is less than a 50% chance of success. So if it's a dead duck, then they can walk away and say, no, you can do that in your own time, in your own money, seller. We're not going to do it. But the next issue is really, is this in the heads of terms or not? The next thing to move on from that is if the builder is going to make an application for planning permission in accordance with the option agreement or conditional contract, is the application going to be made in the sole name of the builder, or is it going to be in the joint names of the seller and the builder? Why does that matter, do you think? Well, the reason is that if the builder decides not to proceed for some reason, or the builder goes bust, then the seller will have a contractual relationship with the architect and therefore or designer, and will therefore be able to use the drawings and plans and reports that are being prepared, and will not have to have arguments with, as is usually the case, with the architects, builders, consultants, quantity surveyors, environmental consultants, that they haven't been paid and they won't let the seller use these documents without being paid. If it's a contractual arrangement, they've got the copyright, etc., in the documents, they've been sent them, then they can use them and will be in a position to then go along to another builder and say, look, we've worked this up, the other builder went bust, or they decided not to proceed. We've got all this already. We've got the consultants team ready. You can use their documents and you can pick up where they left off, and we can carry on under another option agreement or conditional contract. So you can see that a lot of these things need to be thought about right at the beginning so that the document deals with this rather than later on in the day once someone's just signed a standard document without thinking about it. Okay, next thing, let's assume the builder does get down the road and they have a planning permission in their hands and they're thinking, do we want to build this development or not? And it may be that they've got a planning permission for a development that doesn't make any money. It may be that the costs of implementing this permission, because of perhaps the cost of remediation of the soil, the cost of putting in infrastructure, access roads, drainage, etc., is prohibitive, or that the planning permission says that 50% of the site has to be used for affordable housing or social housing or given to a housing association or something of that nature. And they think, well, I've got the planning permission, yeah, but it's a loss leader. I don't want to build it. So if the builder has to buy it, then they will have no way out. And obviously no builder is going to want themselves put into that situation. So therefore, right at the very beginning, in the document, there may be a definition of what is an acceptable or a satisfactory planning permission. And the builder will not have to buy it if the planning permission is not acceptable or satisfactory. And the normal reason for that is that the condition, one of the conditions, is what's normally called an onerous or unacceptable condition. Now, these need to be listed in detail if this is going to work in practice. So in order to deal with this and list these onerous conditions, you need to talk to the consultants on the buyers or the builder side, you're acting for the builder, to propose a list of onerous conditions. And it may be any costs of remediation which are unreasonable or unacceptable, or any unacceptable costs of infrastructure, any unacceptable costs of drainage, any unacceptable costs of remediation, and so on. The trouble is, those are nice words. What do they mean in practice? Or if you put something in like any permission which a reasonable and prudent developer would consider unreasonable. Well, as far as the seller is concerned, he's seeing all this money slipping through his fingers and slipping away. So he's going to say, no, I think this is reasonable. You'll still be making some money out of it. I think you should go ahead. I don't agree that these are onerous conditions. So then starts a high court action over whether or not these are acceptable conditions or not, and whether the builder is entitled to withdraw from the conditional contract and so on. So what do you do to resolve that? Well, again, it goes down to putting in some detail. So you might, if you're acting for the builder, have to say to your quantity surveyors, architects, drainage engineers, highway engineers, give me some numbers. Give me a figure that you think it will cost. And if a developer will have done a mathematical appraisal of how much money he's going to make on this development site. So he'll have assumed certain things about the value of all these things, put those things in the document. So it may say any cost of remediation which is unusually expensive or unreasonable, provided that any such costs in excess of £300,000 will be deemed to be unreasonable. So the developer can say, look, I've had proper environmental consultants look at it. That's what the cost of remediation is. They're saying £400,000. You know, go and get your own consultant if you like, but that's what it's looking at. It's more than 300. I don't have to do it. I can walk away. I can waive this condition if I want to. I think fair enough, but it's up to me. I've got to make sure that I'm not going to be forced into bankruptcy by having to develop a site that can't be dealt with. Other sort of issues that might come up might be the cost of highway improvements works, contributions under a planning agreement towards perhaps local infrastructure or amenity areas or education budgets or health budgets or anything of that nature which the local authority has dreamed up. And in particular, it may be the percentage of affordable housing that is going to have to be given effectively away by the developer in order to get the planning permission, or the number of houses that are permitted, or the number of area of perhaps commercial units that is going to be provided, or the minimum density, or something of that nature. But the more if you're acting for the builder, the more you can put these in as actual quantifiable figures, then the more certainty there is for the buyer and the seller over whether or not this particular development is going to work or whether it's going to fail. So a little bit of time at the outset saves a lot of argument, disputes, and uncertainty at the end. And as I said, because the developer will not have entered into anything like this without having a pretty good idea of what the profit level is, these numbers are going to be available. So rather than using words like reasonable, reasonable, and unreasonable, and all the rest, which is completely meaningless because there's nothing to which to measure them mathematically, put some actual numbers in there. So as I said, this applies for conditional contracts as well as options when you've got any sort of obligation on the builder to do or buy or spend money, etc. Put some figures in there. Right. Next thing to think about is, I remember coming across an agreement that a well-known house builder, names will be withheld to protect the guilty as well as the innocent, and the seller had entered into a conditional contract. Sounds good, doesn't it? The builder has a conditional contract and must buy the land if it gets planning permission. So you think, well, that's good. It's much better than an option. The seller's going to know that they're going to get their money if they get planning permission. However, the condition said the builder must buy the land on the grant of an acceptable planning permission. Definition of acceptable planning permission. An acceptable planning permission is a planning permission which is acceptable to the builder in all respects, and this decision is in their absolute discretion. Right. Now, I want you to put in the chat room where you think that is really a conditional contract or whether you think it's an option, in effect, even though it's got big letters at the front, a conditional contract. So type something in there if you find out where the tap chat. What do you think? Are you all still awake? What do you think? Let's see what's the chat going in there. So it's got big letters. Yeah, it's really an option agreement, Gillian and Ria. See what I mean? You've said, oh, we got a conditional contract. And I said to the seller, you know, why on earth did you agree this? And they said, well, that was the only, they say that it was either an option or a conditional contract, but they could only agree a conditional contract if they had absolute discretion over the planning permission. But a conditional contract is better. No, it's not. It's the same. You've not really thought this through, so it's tough. So it's more akin to an option. Yeah, absolutely right. So think about how much you, as the seller, want to tie in the buyer and how much the buyer might be able to exploit this by putting in things like in their absolute discretion, rather than having easily measurable ways of deciding whether they're being reasonable. If the seller insists on having an objective standard on this point, the option is not really an option and it's starting to move towards a conditional contract. However, so you've got an option that says the builder must buy it, it's a conditional contract, even though it's got option on the front. If you've got a conditional contract where it says the planning permission is approved by the builder in their absolute discretion, it's more than, it's really just an option there. So it's not, to say, just a question of picking up a PLC document, printing it off, topping and tailing it with names and prices and rushing it off to the other side. Deposits and option fees. I've already mentioned this. The deposit is possibly on an option agreement going to be a nominal amount, like enough money to pay for them to go to Disneyland, perhaps £5,000 or £10,000. But then when the builder exercises the option, then that will only be when the price is known, once it's gone through the valuation procedure. And normally the builder, when they serve their option notice, will have to pay a figure for an option fee. It may be not possible to quantify at that time. It may be a fixed figure, or it may be because the process has decided the price before the builder decides to sell the option, which is probably normally the way of doing it. Then the figure will be known and the 10% is then payable, which is then part of the consideration for the transaction. Now, I've used a word there, consideration, which is used in stamp duty land tax. Be aware that an option under Section 46 of the Finance Act 2003 is a land transaction. Even though no title transfers, it is a land transaction and is subject to stamp duty land tax. It is not stamp duty, as I've been saying for the last 20 years. It is a land transaction tax, and options are land transactions. However, if the option fee is lower than the nil rate figure appropriate for whether it's residential or commercial property, 125 or 150,000 respectively, it is not subject to SDLT. But when the purchase goes through, then the consideration is normally going to be the deposit fee and the option fee and the final payment all added together. Okay? It does get complicated where there are assignments to non-connected parties, but that's another lecture, another time. But I mean, I remember talking to a very impressive firm of solicitors who had paid a 2 million option fee, and they hadn't submitted a tax return on it because they thought it was just an option in it. It's not a transfer. And I said, no, it's not stamp duty. It's SDLT. You should have paid £80,000 SDLT, and you should now submit a penalty, voluntary penalty, and the HMRC should also charge you interest on that if they pick it up, etc. So normally this isn't a consideration which is chargeable to tax because it's less than the nil rate bands. But normally the ultimate completion of it will add the two figures together. Okay. The next thing, the price. How are you going to work out what the price is for the conditional contract or the option agreement in both cases? Well, I'm looking at my clock. It is now 10:30, so your brain is probably exploding at this point. So do you want to take a 5-minute break to 10:35 for a quick cup of probably chamomile tea, and then we'll look at figures on price and maths and weapons of math destruction. How does that sound? Yeah? Is that okay? I hope you find this combination of interesting and terrifying. All right, so I'm going to switch my camera off and my mic off, and I'll switch it on again at 10:35. Okay, we're back. So hopefully you feel refreshed and ready to go on the next part of the journey. So the price. Now, I've already talked about the competing interests of the buyer and seller and the attempts by one to try and confuse or outdo the other. So at the very outset, it should have been agreed in the heads of terms how the price was going to be assessed if either the conditional contract became unconditional or if the option notice was going to be served. And normally the parties are able to agree it or negotiate it informally by referring it to their own individual valuers or advisors on how much it should be. And then obviously they may have diametrically opposed views on this, and it may be something that requires complicated calculations and so on, and deductions, and rarely will it be entirely agreed amicably. There may be extended negotiations, but ultimately they may fall out a lot, in which case it needs to be referred to a third party to agree what the price is. And normally this normal sort of expert type situation will arise that if they can agree on an expert to decide this, usually a chartered surveyor of some sort, valuation surveyor, red book surveyor, as they're called, then because normal chartered surveyors can't do land valuations, the only people who are allowed to, who have got professional indemnity cover, are what are called red book valuation surveyors, because there have been so many negligence claims against surveyors that the only ones who are allowed to do these sort of valuations have to pay an extra premium to cover the risks on that. So it may be that the parties can agree this, and if not, then the president of the RICS will appoint a surveyor to assess the value in accordance with the terms of the document. So the obviously the surveyor, the expert, will look at the document and see what the structure is and how it's going to be calculated. Fine. So the valuation, it's not just going to be what's the value of the land. The document has to guide the surveyor on a variety of assumptions and disregards, rather like that on commercial leases section, if you're aware of that, and also the date, because if you've got something where the date of valuation is the date of the service of the option notice, it might take 6 months or a year if there's a dispute to actually agree what it was. And that could be quite difficult for both parties because the price may go up or it may go down in that period quite significantly. And that may be, it's got an equal chance of being unfair to both of them. So it may be more appropriate the price is assessed as at the date that the surveyor makes the decision, because then it will reflect whatever has happened in the market. So make it clear what the date is, and that's often unclear. It just says the value will be assessed. It doesn't say as at the date of whatever. And then there are lots of disputes over what the discounts are and what the deductions are, because you've got to make sure that there isn't any kind of element of double discounting. Like I said before, that the builder saying, well, you know, I'm going to have to spend £50,000 on architect's fees and £30,000 on environmental testing and analysis and modelling, so I want to knock £80,000 off. Well, do you do that before or after the price valuation? So is it £1 million less, let's say £100,000 for costs, and then the price is £900,000, and then the builder says, well, I want a 50% reduction on that to reflect the uncertainty and the money I've laid out. Well, that's going to be a different figure from where you say it's £1 million, 50% of that, and then knock off the £100,000. You see? So make sure this calculation is going to be clear, and you may need to have formulae written out. We'll talk about that later, or even Excel spreadsheets in there so that it can be seen how this calculation is going to be done. So if the builder is going to deduct all of their costs and expenses, then 50% may be too much. It may be 75%. Again, you're not a valuer. You shouldn't try and get involved in that, other than point out where there is double counting and points of principle and so on, and let the qualified valuers or experts advising on both sides help you advise and draft the calculation of the price that will then be given to the expert in the case of dispute for them to work it out. So, and the next thing is other points on valuations. On the top of bottom page 7, top of page 8, the normal common things that will be set out in the document is that there'll be a list of assumptions by the expert, such as the values will remain static during the period that the property is put to the market, that it would be put to the market for a reasonable period of time, it would be openly marketed, there would be no account taken of a purchaser with a special interest, which might artificially inflate the price, such as a next door neighbour, and that the option land has no particular ransom value to any other piece of land, and that there are willing sellers and buyers. And this is all set out both in Gavin the Cat's book or also in the RICS Red Book valuation. Now, excuse me, I'm going to sneeze again. The Red Book is immensely complicated. Excuse me. It is not simple. There are pages and pages and pages. You can actually download it free of charge. It's not shrouded in copyright like everything the Law Society produces for us. And you need to go to the surveyor and say, well, is it a straightforward Red Book valuations, or does it have to be tinkered around with? And if you just say a Red Book valuation, then that's generally Leshat thinks going to be preferable to the seller, whereas developers will want it defined more carefully. And for example, pre-planning or site promotion costs would not be deductible in a Red Book valuation. Preliminary costs of highways and environmental consultants would not be deductible. And there could be double counting of the same item if you deduct, say, 50% off the top to reflect the risk to the builder, and then deduct these figures again. So these things are complicated, and it could be worth a hell of a lot of money to both parties. And only too often, people just want to get a piece of paper signed without realizing 2 years down the line that that rush has cost them £1 million or 100,000 or something of that nature. So make sure it's agreed at the outset before you start drafting things. And also, if you're dealing with a complicated situation, which you probably won't be most of the time, you may have perhaps a number of different parcels of land. And I remember a colleague was dealing with a site where our client owned a piece of land that was horrifically contaminated, so bad that leachate, which is like stuff that comes out of landfill sites, was coming out of the ground and flying across the site and across the roads and things. So it was an agreement whereby there were 3 house builders and us, and our piece of land was essential, because without our piece of horrible dirty land being used as a piece of open space, it would have to come out of the other builder's land. So it was a big site. So they were saying, well, when this all goes through, you get nothing because your land's worth nothing and we're doing you a favor taking it off you. And we were saying, that's not fair, because without our land, your land would be worth nothing, because you need this extra land in the jigsaw. So there was a sort of equalization value, a sort of averaging of the values across the site to work out how much was going to be paid for the land and so on. See what I mean? So it can be quite complicated. The other thing to be aware of, as I mentioned on page 8, halfway down, is that the builder is going to try and push everything onto the seller, so that the costs, all the costs of remediation and blah, 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 is going to be a deduction from the price that he ends up paying. Well, that means that there's no incentive on the builder to reduce these monies. So if the council says, well, we want £100,000 spent on this, the builders say, fair enough, I'm not paying for it. It's going straight through to the seller. It gets deducted off his share. So yeah, jobs are good, let's get it done. £100,000 sorted. Whereas the seller will be saying, just a minute, that should only been 25,000. I'm paying for all this. Surely you should have negotiated that down, or surely that's not fair. The builder say, well, that's not what it says in the document. It just comes out of what you're getting. So if you had a land promotion agreement, like I mentioned at the beginning, there would be a negotiation agreement between the parties over what was appropriate, and the builder would be keen to minimize these costs because that way it would increase the profit, which would increase their fee. So this sort of thing does need a lot of thought before you rush through it. Social housing issues, affordable housing, council housing as it used to be, and this sort of thing is usually required under any local planning authority's plan. And the government says that something like 20-25% of all housing that is given planning permission should be affordable housing or key worker housing, or other phrases are used. Now, the problem with the builder is that they may have 100 houses and 25 of them have got to be social housing. They can't sell them. And it may be that this has got to be given away. The land may have to be given away to a housing association. Or it might even be that they have to build the houses and give the land and the houses to. And the percentages can be quite high. 25, 20, 50, 15, 20, 25% is not unusual. In some cases, councils are trying to screw the builders for 50%. Now, they're not going to make any money if they're giving away half the land to a housing association, sometimes with houses on it. So you can see that this has to be used in the calculation. Sorry, somebody just come in there, and sorry if you missed the last couple of minutes. I hope it wasn't confusion on the timing, but it was only 5 minutes. So therefore, how is this going to be calculated in it? And is this value of the social housing land going to be deducted from the value of the site generally, or the discount, or something else like that? There's all sorts of different ways of doing it, and it could be, therefore, that effectively the seller loses the value of this, or the builder reduces their profit, or sometimes. But someone's got to run the numbers on this and try and work out what the possibility is. It may be that the land is sold, it may be it's given away, it may be it's given with houses on top to a housing association, and how is this going to work out on how much money the seller is going to get? So don't rush that bit through. Then what you often find is, as I call it on the bottom of page 8, what I call weapons of math destruction. And there have been no end of cases appearing in the High Court of Appeal where the numbers haven't really been worked out. Now, most people became lawyers because they were bad at maths. If you hated maths, why would you want to be an accountant? Let's be a lawyer. That's easy. I don't have to deal with maths. Oh God, I'm doing property development. Now I've got to deal with maths. What I often see is, because many people who are lawyers are not used to sort of multiplying, dividing, formula, percentages, brackets, and things like that, which you'd have done if you did maths, they will try and deal with it by using long sentences. So if you can all mute your mics, because I can hear the background noise for somebody. I don't know who it is. Can you mute your mics, please? Thanks. So the sort of thing you might get at the top of page 9, the Chartbrook versus Persimmon Homes case was legendary on this one. It said effectively it was an overage provision, and it said the additional payment will be 23.4% of the price achieved for each residential unit in excess of the minimum guaranteed residential unit value, less costs and incentives. The trouble is, that could be interpreted mathematically in two different ways. First of all, you take the unit price and you knock them both off, and then you put 23.4% of that. Secondly, you take 23.4% of the sum and then you deduct it. And the difference in working that out was £3.6 million. Persimmon said it was only £800,000, and the seller said, no, it's £4.3 million. And the judgment is interesting because the judge says, well, look, there is absolutely no way of working out what either party intended, but I have to work out what I think they intended from an objective viewpoint. And I think it's the lower figure. So because of using a rubbish paragraph like that, it led to uncertainty. Whereas if they'd used a mathematical formula with the brackets in the right place and the minuses and so on, then they would have each known at the outset what they were going to get. So always use a formula is my strong recommendation. Always get someone who's done some maths to check it. Get the surveyors to check it. Run some examples through. Have some worked examples in the document, because if there is a worked example in the document that you're both happy with, but the actual formula doesn't give that answer, then any judge trying to interpret the document will be guided to see what you meant by looking at the agreed work example. So there's less likely to be scope for argument and dispute, etc. So yeah, that's a nightmare case. And there's seen many, many cases when you're looking at it, you're thinking, what on earth did they have in mind here? And even worse, if you look at the practical law precedents, apparently because you can't put formula on a website, or that's what I was told, they have to use long paragraphs, which is ridiculous because it's all got to be HTML or something, and you can't put the minuses and the brackets without it garbling it. So they put long, which just don't do that. Make sure you have mathematical formula rather than long, particularly difficult sentences with brackets and without brackets and multipliers and things like that make the answer clear. The next thing is make sure it's clear in the document, whether it's a conditional contract or an option, when is going to be the date of completion. And I remember looking at one case where neither me nor the buyer nor the seller, I was acting with the bank, could work out when completion had to be, because it all said that completion will be 20 working days after this, which will not be sooner than that, but not after that. And we had to say, well, nobody's got any idea when completion has got to be. And so particularly if it's got multiple conditionalities and extensions for planning appeals. So just make sure, take time to work out what the completion date is going to be. The next thing, again, on conditional contracts or options, is do you, as the builder, want to impose restrictions on the seller over what they do? Because often you'll find sellers will suddenly think, oh, I could have sold this land to another builder for more money because they've offered me a better deal. So they might think, well, I'm going to not cooperate. I'm going to be as awkward as I possibly can and refuse to enter into any documentation or drag it out or delay it, or I'm going to object to the planning permission. I'm the owner of the land. They're applying for planning permission. I'm going to object to it, and that will scupper it all, and then I can sell it to the other builder. So you may have to put restrictions on the seller saying that they will not make any objections, they will not make any planning applications themselves, they will not lobby against the applications through a nominee or associates, and that they will cooperate in all regards with all steps in the application. So it may be that there is some additional land that you might need as well. You may have to say that the seller will give any additional rights, easements, additional land, and such, like drainage rights, access ways, vision space, and so on, as part of the development, and they will include that in the optional conditional contract, and they will not charge a ransom payment or seek a ransom value for that, just to make sure that everyone's trying to work together on this. And like I say, you don't get this sort of argument with a land promotion agreement because everybody's really on the same side. They're trying to make this work. They're trying to do it as cheaply as possible. They're trying to maximize the profits, and they're not trying to exploit or outmaneuver the other party. Planning obligations. Now, how does this work? Planning obligations. Right, a planning obligation. And again, I don't know how much you know about this. Obviously, local authorities can object to an application if they don't think it's in accordance with government policies and their own local plan policies, and also if they think that it's going to perhaps require additional roads, highway improvements, infrastructure, social housing, and so on. But you can't put positive obligations in a planning condition. You can only put negative things. So you can't have a planning condition that says it is a condition of this planning that the builder will pay us £100,000 towards social housing, or is a condition of this planning commission that the builder will provide play equipment on an area of land of half an acre shown on the plan and we'll give it to the district council to maintain. That's not possible. But if these things are not provided, the local authority is entitled to say, no, we're not going to give you planning permission, and it'd be no point appealing because these have to be required. So this has been thought about in the Town and Country Planning Act by the creation of planning obligations, which can be unilateral or bilateral. So, for example, if the builder is negotiating with the council and they're refusing outright and say, we're not prepared to talk to you, we want 20% housing, we want social, we want this, we want the other, we're going to refuse you, and they refuse you, then the builder can do what's called a unilateral planning obligation, which they can do saying, right, we are going to do a document that says that if this gets planning permission, we will agree to provide all these things, and we're going to appeal this refusal on the grounds that if we go to appeal, we can show that we will do things and you will therefore have to do it. So it isn't usually a unilateral planning obligation. Usually it's one that's negotiated with the council. So the council will say, we want this housing, we want that, we want play areas, we want open space, we want blah, blah, blah. And the builder will say, yeah, it's fine. The trouble is, the builder is just an applicant on a planning permission. They can't say anything that binds the land. And it's the owner of the land that has to enter into the planning obligation. So therefore, in order to unlock the grant of a planning permission, the option or the conditional contract will say that the owner of the land must enter into any Section 106 planning obligation that the builder reasonably wants them to enter into, either a unilateral one in the case of a planning appeal or a bilateral one, they're both entering into it if it's going to be a negotiated consent. And also, if the seller has got a mortgage on it, then the seller's mortgagee would also have to confirm that any rights needed were going to be released. Now, they may not always have to, but sometimes they do. Then, so you've got the situation that the builder will negotiate the terms with the council. So you've got three sides of a triangle. Builder negotiates with the council what the terms are. They then use this agreement, option agreement, conditional contract, to make the landowner enter into the planning obligation with the council. So they then enter into it. They then give the planning obligation to the council. The council says, great, we know that if we grant this application that we've got ready to send out, this work will be done and we will get this money. So they then send the planning permission, now they've got a planning obligation, to the builder, who says, great, I've now got a satisfactory planning permission, which allows me to trigger the option or conditional contract, which means I then buy the land, which means that I'm the one who now owns it, which means that I'm the one that is bound by the Section 106 agreement because they run with the land. And when I start the development, I will then be bound to provide this money or housing and so on. So these negotiations often take a couple of years to negotiate. And you'll have this three sides of a triangle thing where the seller has to agree to enter into any Section 106 agreement the builder reasonably thinks is necessary in order to procure the grant of the planning permission. Now, that's a bit of a head wrencher, but people often wonder why it is that the builder doesn't enter into it. The answer is it's only the owner of the land can enter into it, and the builder isn't, but he will be bound by it when he buys the land. Now, obviously, the owner is concerned about what the terms of this Section 106 agreement is, and they'd be concerned if it had any effect on any other land that they had joining. So normally there will be provisions in the conditional contract saying that the seller will expect the builder to indemnify them against any costs, and also there'll be no trigger on paying any money or doing anything until the development actually starts. And obviously, while the owner is owning the land, they can stop any work doing, which would start it. But once they've sold the land and got the money, they frankly don't care. So normally there'll be provisions about the reasonable approval of the seller to any proposed Section 106 agreement. And normally the same provisions about onerous conditions will apply to the requirements of the council as apply to any provisions in the planning permission itself. Okay, right. So The next thing is that normally the obligations to do things under the planning agreement are triggered by the starting of the building works, known as commencement of development under the Planning Act. However, this is very widely drafted. So simply, let's say the builder buys it and he has to do some perhaps archaeological investigations or dig some trenches or put an access road in just to get plant onto site. Bang, that's implementation of a planning permission. Bang, he has to pay all this money. Bang, he has to do all these things. So he doesn't want that. So normally there will be a little addition to the planning agreement saying that doing all these minor things will not trigger the obligations under the planning permission or the planning agreement until the development starts for real. Okay, so has everybody got this point of the three-way sort of work on planning obligations and planning agreements? Everyone clear on that? If not, speak now. Now, the trouble is, you get a battle between the council and the developer, where the council is trying to get as much money out of the developer as they can, because obviously more money they get out of the developer, less money they have to provide for social housing and infrastructure and roads and highways and all the rest. So this would take years to negotiate. And often there are specialist consultants who know just how to negotiate these things rather than you, thank God, have to be involved in this. And so the government thought this is holding up planning permission. So they introduced in 2016, way before that, sorry, this idea of community infrastructure levy. So that instead of the negotiations having to take place with each party trying to get one over on the other, the council and the developer, there would just be a list of costs, so that for every house that you got planning permission for, you'd have to pay £10,000 or £20,000 towards the council in providing all these things. So they didn't have to get into long-winded negotiations of how much and so on. So it sounded a great idea in principle. You could just look at the list of costs which each council would have to produce, and then you'd make your application. No need for a Section 106 agreement and all these negotiations. Trouble is, there's a damning report a couple of years ago that said it has completely failed to deliver, that most of the planned improvements that councils were supposed to spend, the money they got on it, were never provided because they didn't have any other money to supplement what they got from the community infrastructure levy, because it cost more than they thought. So this is going to be changed in a couple of years' time. Obviously, any payments under community infrastructure levy, in cases, about 50% of the councils in the country have community infrastructure levy, these should be taken into account in any calculation of the price or overage too. But unfortunately, the community infrastructure levy regime cannot deal with provision of social housing. So you might have a situation where the council doesn't have community infrastructure levy in force and it's all done in Section 106s. And if not, if it is in force, then you may have a Section 106 just for a limited number of things like provision of open space as part of the site or the provision of social housing, but everything else will be dealt with under community infrastructure levy. If your client does deal with this, you need to advise them that it is one of the most complicated areas to get right. And there have been many, many mistakes where developers have been unable to claim reliefs and exemptions and so on because they served the wrong notice on the wrong form on the wrong person a day late. And don't get your neck in the noose for dealing with this. That's what these community infrastructure consultants, or usually planning related people, deal with. Now, the next thing, mortgagees. If the seller has a mortgage, then if there's any obligation in the Section 106 agreement affecting the seller's land, then you're going to have to get the seller's bank or building society to join in. So things like agreeing to transfer land to somebody else, like the council, you will not be enforceable on the mortgagee unless they've agreed it. So if the builder found that the seller had gone bankrupt and the bank had repossessed, they would not be able to enforce the Section 106 agreement obligations on the council, on the seller's bank. Therefore, the buyer should make sure that the mortgagee, the seller's mortgagee, is a party or gives consent to the Section 106 agreement where these rights have to be released in favour of the council. And the next thing, I've already mentioned this one already, is let's go back, sorry, let's move the slide, is works on third-party land. Be aware that often it doesn't become apparent till partway through the planning application or the development that suddenly they need a right-of-way or a drainage easement or an infrastructure easement of some nature through next door's land. And of course, if it turns out that the seller owns next door's land, they can say, oh, what a shame. I can ransom you now. You've just bought the land off me, but I can have 25% as a ransom value. Ha ha ha. So sometimes you might want to investigate this and say in the document that if there is any requirement for planning permission or infrastructure to carry out works on the seller's land, that they will provide that land or will provide it at a non-ransom value, or they'll grant these easements and so on. And also, it may be that the seller under the contract doesn't own the land, but the seller's mum, wife, husband, company, business does. And that could be used to manipulate or circumvent the option or agreement. So you might sometimes do a quick search on SimSearch to find out who owns the adjoining land and talk to your clients about whether there's any possibility of any access land being needed or vision displays, sight lines, etc. needed when the application goes in, to see whether it might be that you could be setting up to be ransomed there. And if that's the case, you get some sort of agreement to grant easements or options and things like that over the retained land from the nominee or associate of the seller. Judicial review. This used to be used a lot, and there used to be lots of cases on judicial review over either adjoining owners saying, no, we don't agree to this planning permission being granted, or judicial review of the council's refusal to grant planning permission, and so on and so on. But this has been cut down a lot some years ago, so that really any application for judicial review has to be done within 2 months. But the risk is that if you've just got if you've just got planning permission and you're a builder for this site, and you think, great, I'm going to serve the option notice, I'm going to serve the notice of unconditionality on the conditional contract, we're going to buy the land, and you get the land, and then the next door neighbour does a judicial review and gets it quashed, well, the seller's laughing because he's got your money, but you don't get the deal unpicked. So it's unwise to operate the unconditionality or option notice until the period for judicial review has expired, which is normally 2 months. So normally the option is, or the conditional contract is worded to take that into account, to allow them a period for the expiry of this before they have to serve a notice. Next thing to think about is conditions on top of page 11, because you could have a situation where there are conditionals such as conditional upon the developer securing an access way, or drainage, or outfall, or something, or an environmental search showing that the land isn't contaminated. So there may be a number of different conditions, not just planning. And if these are going to be dealt with, you need to deal with them with the same level of detail that you might with the planning permission. So it could be perhaps grant of an easement, release of a restrictive covenant, obtaining of suitable title insurance, satisfactory ground conditions, or even once I saw it said satisfactory funding. Well, I mean, that's completely meaningless. Now, if you've got something that's a wishy-washy, woolly, easy to exploit planning condition, then the seller has to be worried that the buyer will use this to turn a conditional contract into an option agreement. Because even though you've got the planning permission, they'll pull out on the basis that, oh, they can't get satisfactory funding, oh, they don't like the ground condition report and so on, or they couldn't get the satisfactory title insurance, you name it. So if you say, oh, subject to reasonable or satisfactory, well, again, that's difficult to pin down. So if you can try and pin it down in some ways, such as having a draft of the deed of release or a draft of the deed of easement required, or a draft of or some sort of provision that will deem some things to be acceptable or not. Environmental preconditions are the most difficult, and because you can't tell what's under the ground till you start digging around, and most builders don't want to spend what can be a lot of money on drilling and investigation until they've got the document signed. So problem is, it might take it might take 2 years to get the planning permission, and then they drill the holes and they find it's contaminated, and they could have found that at the beginning, and then they wouldn't have wasted you 2 years of time doing it. So in my view, what I've done in the past is where they want to have it conditional upon environment, I say, well, it's only conditional upon environment for 2 months. Go and do your drilling, find out if you like it before you go and get your planning. Otherwise, you might use this as a way of getting out of it, or you get a planning that you don't like, but you want some way of getting out of the deal. The next thing is onerous conditions. I've already talked about the importance of making sure that these are defined in careful terms rather than just using reasonable, because the builder will say, well, I'm reasonable, and the seller will say, I don't think you're being reasonable, and the result will be 2 years of litigation and a High Court judge deciding what is reasonable or not. If you're a builder, you will want to have a list of these onerous conditions, and then you will probably put a sweeper condition in, such as any conditions or circumstances arising that would not be acceptable to a reasonable and prudent developer. Well, if that's in there, the builder is obviously looking at this as an exit route to get out of having to buy the land. And if you're happy with that as a seller, then you've basically got an option agreement rather than a conditional contract. But it may be that you water that down a bit, or you try and delete it altogether. And it goes without saying that any kind of additional conditions that apply to the planning permission should also apply to any Section 106 planning agreement that the council might expect too. And then also on page 13, don't omit to investigate the property, even if it's just an option agreement, to the same level of detail that you would do if you were buying the land. Because you might, if you've done that, you might have found that there are ransom problems, easement problems, vision display problems, etc. And it would save your client a lot of wasted money if they go and serve the notice and then find, oh God, we can't afford to buy, oh, we can't do it. It's impossible. We've got to buy it and it's useless. If there are disputes, then you've got to think of a way of resolving this without going to court, because going to court, nobody wins, not even the lawyers. Nobody really likes to be a litigator, I'm sure. So how are these going to be resolved? Well, it's less likely to be a problem with a land promotion agreement because the parties have got to work together on things all the time. Whereas with a conditional contract or option agreement, there's the scope for them falling out quite a lot. So normally there will be something saying that the parties should refer the matter to mediation or alternative dispute resolution, because it can be quick, it can be less costly, and more than anything else, it's private. It doesn't get publicized in court papers and that sort of thing. So it could be that certain things are referred to an expert, like financial calculations, valuation, or planning, but anything else, like construction with a meaning or any serious falling out, goes to the courts. I've talked about CIL. What about some technical points on options and conditional contracts? How long have we been going now? An hour and a half. We usually have a 15-minute break at an hour and a half, which is 9:30, 10:30, 11. Right, 15-minute break now. How about that? Is all right? Does that sound good? And then we'll look at some more technical points, and then we'll look at overage. Is that okay? So we'll come back at 11:30. Are we good on that?
Yeah, that's fine.
Yeah, that's fine.
All right, see you at 11:30. Right, we're all back, I hope. More stuff about conditional contracts and options, and then we go on to overage. Right, hopefully you all got the notes. If you haven't got the notes, type in the chat box and Catherine will make sure you've got them. But it is important that you've got the notes. I've got them open on the screen beside me so you can see what I'm doing as I go through. And there are also sent to you a couple of sample precedents from practical law, and the notes that I refer to those paragraph numberings, but do not use those. Use the most up-to-date ones because they're not absolutely the most up-to-date ones, but it's there to give you an idea of the arguments and the structures rather than anything else. So on page 14 of my notes, options need to be registered to be binding on the seller. If it's an unregistered piece of land, then it's a C4 land charge. If it's a registered piece of land, then you can either have a... Oh, sorry, Catherine, you didn't... I usually like to get people to get them at the same time so they can open them up on the screen and have them a look. If people want to, I can drag them into the chat room. Let's see if it works. So I drag them in. The cursor of Microsoft probably means I can't. Let me just try it again, see if I can drag one in. No, it doesn't have that kind of functionality, I don't think. Let me have a look. Apologies, people, I just assumed that you had them. Let's see if I can send to them now. Sorry, so look. Okay. Oh, you can do them. Catherine will send them now. Sorry, I just assumed that you'd all got them. Me referring to page numbers and all the rest, because it is a hell of a lot to take in if you haven't got the notes to have a look through as you're going on there, because there's some really good notes and there's also some documents as well. So Catherine's going to do that. The chat with Zoom, you can drop things into the chat, but with Microsoft, of course, about 10 years behind everything else, you can't. No, I can't seem to a way of doing it. More actions. No. Full screen gallery together. Chat. No, chat is just chat. Anyway, Catherine will send you those in a minute. So do try and open them. And we are on page 14. And my apologies, I should have checked that at the very beginning. So options, as I say, unregistered land, C4 land charge, registered land, either a unilateral notice or an agreed notice. Now, the problem with an agreed notice is that everyone can see the document on the land registry. So you might not want that if you're a developer or a landowner. So you might use a unilateral notice, but the unilateral notice is something that the landowner could apply to have removed. So it's less secure for the developer, but perhaps they could put something in the option agreement saying that the seller will not apply for the removal of it. So they could get an injunction against them if that was the case. But it does need to be registered in order to be binding on the seller. And if it's not registered, then the seller can sell it to whoever they want. Still be liable in breach of contract, but the land will have gone. The other thing to think about is what if the seller does say, well, you know, I might die, I might get divorced, it may be a company, we may want to sell it. Are you going to allow the seller to sell the land if you're a builder? And if you do, then you've got to think about how the new buyer is going to be bound by that. And normally there'll have to be a restriction on the register saying that there will be no sale of the land without the new buyer entering into a covenant to observe and perform the terms of the option agreement or conditional contract and to perform all positive steps. The next thing on page 15 and 16 of my notes is all about reasonable endeavours. Now, you see the words like all reasonable endeavours, best endeavours, or just reasonable endeavours, and there's nothing to really say what that actually means in practice until the most recent case. There have been previous cases. The most recent one is Brooke Holmes, which said that reasonable endeavours is the least demanding obligation. Where there is an obligation to use reasonable endeavours, a party must generally pursue only one reasonable course of action, and the party's own commercial interests would not need to be sacrificed. So that means that if it's going to cost you money, you don't have to do it. But if it doesn't cost you money or put you out too much, then you would be expected to do it. Obviously, a little bit of money would be okay, but not a lot of money. All reasonable endeavours means that all reasonable paths could be required. So that would mean that they would have to spend money and potentially lose it, and so on. So all reasonable endeavours means a lot more. And best endeavours could mean that it would mean that the builder, if it agreed to give best endeavours, would have to do just about anything, including things that would mean that they could be losing money on the whole deal. And this is quite an onerous one. And if you might think there's like reasonable, all reasonable, best, but no, actually this decision said that all reasonable is pretty much closer to best endeavours. So it's a much more onerous obligation to have all reasonable endeavours, and best endeavours is obviously the best. Sorry, obviously. That's an important case just recently. Oops, why have we gone back? Additional contract point on conditional contracts. All the things we've talked about before apply to option agreements, and I've given you the PLC one. But the same issues, just to go over again: price. What's the price going to be? Is it a fixed price? Is it an index RPI price? Sometimes it's an RPI price, or is it fixed by valuation? It's normally going to be valuation. When you look at the heads of terms, again, same issues. Who's going to pay for the preparation of the planning application? Usually the builder. Will the builder have to use all reasonable endeavours, best endeavours, or whatever to apply it? How much input does the seller have? Do they have a right of veto, like I said before? Is it going to be specified that they must apply for a certain number of units, houses, or area? Can there be variation? And can or will they have to appeal against any refusal? And same provisions about Section 106 agreement and community infrastructure. Same provisions about what is an unacceptable condition and so on. But even more important, you may not have a need to have anything about unacceptable conditions in an option agreement, because it's just an option agreement. The builder can use its discretion whether they want to build it or not. With a conditional contract, this is going to be much more important. The developer's first stab will be to try and get absolute discretion over whether planning permission will be acceptable. Most sellers won't agree that and will want arguments about onerous conditions and definitions of satisfactory. So the seller may say, well, look, if you get any planning permission for more than 50 houses, it will be deemed to be acceptable. You can't try and wriggle out of it. You've got to buy it. Or it may have a provision that if there is any requirement for less than 25% or less social housing, that will be deemed to be an acceptable condition. And so you can't try and wriggle out of it. And you may have maximum costs for infrastructural groundworks and road costs, like I talked about before, which may be reasons for the builder to get out. But you may have deemed costs. So if it says any costs of up to £50,000 on roadworks will be deemed to be acceptable. So again, the builder can't try and wriggle out. Then, as I said before, it's not going to be unconditional until the judicial review period expires. And is it going to be triggered by full planning permission, or is it approval of reserved matters, or things of that nature? But again, the same arguments, very important arguments about definitions of onerous conditions, and any consultants who are going to produce calculations, figures, or drawings, the seller will want to get some sort of duty of care or joint appointment or something of that nature, so that they can then sue or complain against them if the figures turn out to be completely wrong and they've lost the opportunity to sell the land. But there could be other conditions such as Japanese knotweed, ecological issues, sustainable drainage, travel restrictions, vision splays, third-party land needed, roundabouts, cost of traffic calming costs, education contributions, and all of this sort of thing stuck in there. And also, page 19, there might be a list of buyer's unacceptable conditions. You could have a possibility that you will always have buyer's unacceptable conditions, all of those things there. But there may also be seller's unacceptable conditions if it might affect the adjoining land. And as a bit of a warning, they do a development case versus McLagan Investments, which is basically the development arm of Asda Supermarkets. On page 20 there, they had a whole list of conditions to do with the certain whether all of these conditions had been discharged by the unconditional date or only some of them. But unfortunately, the wording was a bit woolly, and I won't expect you to understand it at the moment. You'd have to sit there and read it a bit first thing in the morning with a double espresso before you can see the way the judge thought it. But the way I and anybody else would have interpreted it is that Asda had to get all of the conditions done by the unconditional date. The way the judge read it, that wasn't the case. It meant that if they hadn't got, if all of the conditions had not been discharged, then Asda could rescind the agreement. And the difference was whether they had to pay £11.5 million or not to buy the land, and they lost. So they had to pay the £11.5 million paid. They couldn't rescind. They had to buy the land, even though they didn't want it, because the only way they could rescind it is that if none of them had been discharged by that date. So just an indication of just how tricky long clauses and conditions be, and how easy it is when you're looking at something complicated to only see the interpretation that is what you want to see, and always give it to someone else and say, can you think of another way of seeing it? Have I missed this? Have I got this wrong? Given the Duba Developments case, you don't want to be on the receipt of a complaint or something saying, oh, you didn't see that. And of course, High Court judges have never done property development. They don't know anything about property development or options or conditional contracts. They're just coming to it fresh, and it can be quite arbitrary what their decision is. Long stop dates. Normally, there will be a provision in the document saying that if you get up to the end of the 2 years and there's an application in, but it hasn't been decided and it's still being negotiated, that the option period can be extended. Usually, if the builder wants to extend it, it could be extended another 6 months, and then another 6 months, and then another 6 months. But there comes a time when both parties think to themselves, we've had enough of this, we want to pack it in. So that's what the long stop date is. And the reason the builder will want it is because he doesn't want the seller having a go at him saying, you've got to appeal, you've got to use best endeavours, you've got to do this, you've got to spend more money, you've got to spend more time, because the seller's seeing this money slipping away that he's hoping to get. And the builder wants to say, look, I've given this, we have a long stop date of 3 years. We went past the 2 years, it's still under appeal, we're still negotiating, we've lost patience with, we want to walk away. This is reasonable. So there is normally a long stop date. And the seller may think, well, I just want to try somebody else. You've had 2 years. Now you've had another year. Let's just call it a day. It would normally say that it wouldn't automatically end at the long stop date. But the parties can obviously agree to a variation if they want to at the time and say, well, all right, let's amend it to allow a further extension of the long stop date. But they couldn't force the other person to do that. But it would mean that if both parties are happy to run along with it for a bit more, they could do. But if one of them then, after they got to the long stop date, decided to have had enough, they can serve a notice and walk away from it. There's exactly the same provisions as I mentioned before in relation to what sort of planning application is made, what approval the seller has over the application, and any variations or amendments, and the applications and the joint names, so that the seller can pick up where the builder left off if he terminates it, and the need for developers to look at these quite carefully when they take any step in applications and get all appropriate approvals. The purchase price, as I say, is exactly the same things. One thing I want to mention is risk, though. Normally, with a normal contract, risk passes on exchange of contracts, but that isn't going to pass on an option agreement. Notice the risk will still be with the seller until the option notice is served. With an unconditional contract, for so long as it's an unconditional contract, then it should be the case that the seller insures it, and it may be that on the unconditional date, when the notice is served saying this is now unconditional, we've ticked all the boxes, we've got the planning permission, It could be that you've agreed that the buyer will then insure from that date. So that needs to be made quite clear. When risk passes, normally it's going to be on the unconditional date, but very often the seller will also insure, probably because they're required to insure it under the terms of their mortgage, and also for prudent nature, just in case it does burn down, the buyer goes bust, and then they've got a property with no insurance on it. So in most cases, the seller would continue to insure. Okay, well, I'm now going to go on to overage unless you have any questions. So now's the time for you to ask any questions about conditional contracts or option agreements before we move on. I'll just wait and see if anything appears in the chat room, or you can unmute your microphone and talk to me if you want to. No? Okay. Overage then. Overage or clawback? Just a minute, just get the slide up. It's gone for some reason. There it is. Good. Sorry, just got something else popped up. Right. So normally this is a fundamental part of the deal to make sure that the seller doesn't lose out on money that wasn't anticipated. Overage and clawback generally mean the same thing. There are overage precedents, and with the notes you will be sent a copy of some precedents from practical law. I say practical law only goes so far, and Gavin Lechat's book has also got some, and obviously I can't send you those, but it is definitely worth getting. But it could arise in lots of situations. It could be, for example, where the seller needs to get rid of the money now. Needs to get rid of the house now. They don't want to wait 2 years why in this big, expensive to heat 6-bedroom, 3-story house with 2 acres of garden. Then they'd rather be living in a nice flat in Nice and enjoying the weather and not paying heating bills. But if they have to wait for the house to be sold, it means they've got to maintain it, repair it, heat it, and all the rest. And then in 2 years' time, they might be back where they started again. So they might say, well, we'll just sell the house to you now for its worth with the gardens. But then but you have to agree that you will make an application for planning permission, Mr. Builder, and that you will give us some more money when you finally get it. So we can then go down the casino at Monte Carlo and put it all on black. But so it could be possibility that a local authority is selling land and they're worried that there might be a change of use. They might have missed the opportunity to get more money. Like I mentioned, Section 123 of the Local Government Act 1972 requires councils to get the best price reasonably attainable. It could be that you're buying a piece of land and it could be affected by contamination costs. And that might be like reverse overage in some case. It could be that the price depends upon the property being developed and an incoming tenant being found for the shop, something of that nature, and the rent paid could affect the amount of money or the pension fund gets. It could be surplus factories where the company needs to be closed down and they need to get the money out to pay the shareholders, and then they'll worry about getting some overage later. Or it could be sale of a piece of land that a farmer's got to an adjoining house that needs a paddock for their pony, but the builder's actually, the buyer is actually a builder, and the farmer thinks, I don't trust you, I think you're going to try and get planning permission and put some houses on it. So they might want to get more money if the paddock is turned into a development site. It could be the sale of part of a garden. I asked next door neighbour, can I buy your bit of garden? Because, I'd like to have a bigger garden. And they think, as soon as you get that, you're going to redevelop your land and we will lose out. So rather than 20,000 an acre, we want 500,000 an acre. It could be that political reasons, local authority being complained if the price goes up. It could be a disposal of land between beneficiaries on an estate. So they all get, say, bits of the farm, but one of them gets planning permission and the other two don't. So they might think, well, that's not fair. You got the bit of land that got planning permission, so we want some of the money. It could be personal planning consent. You buy a piece of land, it's got personal planning consent, but the seller knows that you might make it full planning consent when the value goes up, and therefore we want more money. Or Section 106 agreements, where it's an open space land given to a local authority or by a local authority, and then the use changes and the value goes up, and whoever owned it originally wants some more money. So the first thing to think about is, as I mentioned on page 26, why are you doing this? What is the reason? And is it something where you're getting the full value of the land? Is it even necessary? Or how is the seller also going to be in a position to make sure that they are paid the overage? Because if you sell a piece of land, once you've sold it, you don't need agents, valuers, surveyors and things. If you sell a piece of land with overage, then you, the seller, is going to have to police it and make sure that the buyer doesn't do something, change of use, development, occupation. And if it's a piece of land in another part of the country, and you're, say, a company and you've got land you just sold in Liverpool or in Cornwall or Northumbria or something, in order to keep tabs on it, you're going to have to send a valuer up or a surveyor or somebody up there all the time to see what's going on. And then if something is going on, you're going to have to appoint surveyors and lawyers to try and negotiate how much money you're due and check that there's not someone trying to pull a fast one on you. The next thing is, what is going to be the trigger? Now, we'll talk a bit about trigger agreements, but I've seen many cases where this has gone wrong because people didn't think of the particular trigger. For example, is the trigger the grant of planning permission? Is the trigger the disposal of the land? Is the trigger the grant of a lease, or is it just the transfer of a freehold? What about a permitted development rights? Would that be possibly a trigger? You see, you can now change the use of land without necessarily getting planning permission because of the widened General Permitted Development Order 2015 controls released as a result of COVID. So you can change an industrial unit to a house, believe it or not, without planning permission. Obviously, the value of an industrial unit is much less. And if you've sold the land assuming it was going to be industrial units and it turns out to be housing, you'll feel a bit hard done to and you'll want some more money. So the next thing is, how is it one bite of the cherry or not? Another example from my experience, overage payable on same argument, development. So there was development, but there was a recent case where the development in case was only putting a new roof on the shed of the farm. Whereas what the seller had thought was the development was making an application for development for 15 houses. And the argument was that the trigger? If it was a one bite of the cherry trigger, then the increase in value from putting the roof on the shed would be pretty much little. The seller would get £1,000 or something, and then the overage would be released. And then when the developer put in the application for 15 houses, there was no overage to pay. If it was a multiple bite of the cherry, and I can't think of a better phrase than that, then each time there's a change or a trigger event, there's a recalculation of whether more money is payable. Now, the trouble is, if you just look at the new increased value and compare it with the price you sold the land for, and then you say, we want 50% of that, what you're effectively getting as the seller is overage as a result of the general increase in land values. So if there hadn't been any increase in value because of the change of use, then because land values have generally gone up, you'd get some more overage, and that's generally not felt to be fair. So what you normally say is that once you've worked out what the trigger events is, and if there has been a trigger event, you get a valuer to value it immediately before the trigger event and immediately after it. So you're really only entitled to a cut of the increase in value that's as a result of the trigger event rather than the general increase in value. Do you see what I mean? Hopefully it's a bit like head wrenching. I bet you wish you had an espresso in the break. The other thing is disposal. I'll give you an example from my experience. A piece of land was sold by a farmer to a logistics company with the intention that they put a logistics unit on it, and that when the land was sold sold to a developer. That's right, sold to a developer with the intention that logistics like warehouse type thing was built on it, with the intention that when it was sold with the warehouse on it, the farmer would get some money. Well, what the developer did was, instead of selling the land to the logistics company, they sold the shares in the company that had bought it, which meant there hadn't been a sale, which meant there was no triggering of payment of overage. You see? So disposal generally means grant of lease and transfer of land. It wouldn't cover change in ownership or control. And this is the sort of thing that buyers will try and exploit so they don't have to pay any overage. Next thing, will the sellers or the buyer's mortgagee need consent? The buyer's mortgagee will have to agree that if they repossess the land, if the developer builds it and goes bust, or before he sells it, that then the builder will have the land repossessed by the council, by the bank, and then the bank will then pay the overage to the seller. And then, is this overage really likely, or is it a very slim possibility? And what happens if the developer is going to sell it off in bits, in tranches, or are they going to sell it all off in one go? Then does the seller want to have any control of any future planning applications or not? That's a tricky one. And then don't forget stamp duty land tax, because as we'll talk about at the end, SDLT is payable on future consideration at the moment that you buy the land. So I buy the land from you subject to potential overage of £1 million, then I have to pay SDLT on the £2 million I pay for the land now and the £1 million I might pay in the future, which seems very unfair, but that's what the Finance Act says, and we'll look at that later. Many people get that wrong. They don't understand that you have to declare it but apply for deferment of the payment till the contingency arises, so that if it doesn't arise, you don't pay it, but we'll talk about that later. So overage is really like nailing jelly to a tree, to be honest, to try and get it right. And there are a number of ways you can reserve overage or clawback revisions in a development agreement. It might be in the transfer, it might be in a separate agreement. The most usual way of dealing with it is a positive covenant by the buyer to pay the overage to the seller, protected by a restriction on the register, so that the seller knows that the buyer can't sell it on to someone else without the seller giving their release of the restriction. It might be reserved on a restrictive covenant. For example, I'm selling a piece of farmland to you, and you say it's just for a paddock for the back of your big house, but I'm worried about you using it for some development purpose. So I, the farmer, I'm not sure that you can develop it, but I want to be protected. So I've got a lot of land left. So I might say there's a restrictive covenant on it that you can't develop that land in any way or use it for anything other than a paddock. And obviously, if you do, then you're in breach of the restrictive covenant and I will sue you. And we will agree terms for the release of that restrictive covenant. There are problems with that, but it might be something that's only a very slim possibility, but the farmer doesn't want to lose out. It could be a mortgage, though that's very unusual. It could be a lease, or it could be a ransom strip. But in any situation where the seller is owed money and that hasn't all been paid on the purchase of the land, that creates something called an unpaid vendor's lien, which will bind successors in title. So you don't want that to happen if you're a buyer, and you need to have a clause in there saying that the obligation to pay the further overage does not create an unpaid vendor's lien. And that will be of great importance to your bank, because they would not want the lien taking priority over the bank's charge should they repossess it. So there's normally a clause in there saying there is no unpaid vendor's lien. So the normal way of dealing with it is to have a positive charge protected by a restriction. And obviously, if the buyer then sells the land or wants to sell part of it, they're going to need to get the seller's consent to the lifting of the restriction. And the seller's not going to do that unless he knows he's going to get the money. But the problem is, this positive covenant is not enforceable. This positive covenant to pay money by way of overage is not enforceable because of the general rule of English land law that positive covenants don't run with the land, only negative ones. And to be enforceable, you've got to have this protection of the restriction. Land Registry Practice Guide 19 is the relevant one there, and it recognises that overage does exist, and if it's a term of the agreement that the registered proprietor's powers to make disposition will be limited, you can also apply for an RX1 for the entity of a restriction to prevent a breach of the item, breach of this term. And also a certified copy of the overage agreement. And there has to be a statement in panel 12 of form RX1, or a conveyance certificate must be completed. You have to give details of the agreement and identify the provision in the agreement limiting the registered proprietor's ability to make any disposition. And some overage agreements have an express obligation on a party to apply for a standard form restriction, and the normal one is a Form L. And there at the bottom of page 28, you have the Form L, which says no disposition, and there could be a question over that, can be made other than, and it may be that there are some permitted dispositions, by the proprietor before without a certificate signed by somebody. So it will say no disposal of the land to be made by the proprietor without the issue of a certificate signed by somebody. But this itself becomes problematic. If you're a builder or a seller, you've got diametrically opposed views on that. So the alternatives in the standard Form L for the issue of the certificate are a conveyancer, which could be a conveyancer for the buyer or a conveyancer by the seller, the applicant registration, in other words, the builder or their conveyancer, or it could be Fred, or if Fred's dead, their personal representative, or Fred's conveyancer, or it could be a specified person, not necessarily the registered proprietor, or their personal representative, or their conveyancer, or it could be, in the case of 2 or 3 different people, may need all of their consents, or one of them, or the survivor of them, or their personal representatives, and so on. So it's problematic at that stage. Who is going to give the consent? Now, if I'm the seller, I'm going to say, you can't sell the land unless I give consent. Trouble with the builder is he's going to exchange contracts to sell the land, binding him to complete in 3 weeks' time. But he may be worried that for some reason I might be awkward, or I might be dead, or I might be in the middle of probate. Probate may be arranged for my death, or I might have a lasting power of attorney because I've gone mad or incapable or something of that nature. And he will then be in breach of contract with his buyer if he can't produce the form for removing the restriction. So the builder's view on that is no, we're not prepared to have the sellers deal with it. So the seller said, all right, what about the seller's conveyancer, Bloggs & Co. solicitors? Okay. But the builder will say, well, what happens if in 3 years' time Bloggs & Co. has been dissolved or it's been taken over and doesn't exist? Then there won't be anybody specified in the restriction to actually deal with it. And what about then the seller says, well, all right, Bloggs conveyancer or any other conveyancer appointed by me from time to time. Well, then the seller's saying, well, yeah, but you might be awkward and I'll be in breach of contract. And the builder will say, well, look, you know, trust me, I'm a developer. It's my certificate. And the seller says, I don't trust you. You're a developer. That's an oxymoron. And he said, all right, then, me or my conveyancer, you can trust Bloggs & Co. or Jones & Co. They're good quality firm of solicitors. Yeah, but how do I know as a seller that Jones & Co. are going to cooperate and not going to say, no, our client said don't do it? So you can see that there's all these potential arguments that need to be thought about right at the very beginning. Who is going to be the certificate? Because will me, the seller, be cut out of the money because some dodgy activity has gone on and the buyers, the builders conveyancer is complicit in signing off something that they shouldn't, and what recourse have I got against them? So there's going to have to be some careful thought about who is going to issue the certificate. And the overage documentation may need to have a strict contractual obligation on the seller to produce such certificate within a set period on payment of the overage, or prior to the completion, but to be held by the builder's undertaking until payment is made. So you need to think about the process of making sure that this restriction is going to be removed in a way that the buyer and the seller is going to be happy. And it may well be that the most cautious way is that it will be produced by the sellers or their conveyancers within 14 days of payment of the overage due, as certified by whoever is going to certify it, and that this will be provided prior to completion to be held by the builder's solicitor in escrow and will be released on payment of the overage, and then to be held on a solicitor's undertaking to the seller, so that the seller has got some way of enforcing that against the builder's solicitor. Then ultimately, if it all works, restriction is removed, the money is paid, everybody's happy, and so on. Now, one of the issues that can arise is that very often the bank lending the money to the builder will be worried about the overage, because they don't want to have the overage paid out if perhaps there's not enough money, if they repossess the land, to pay off their mortgage. But the seller's going to say, I don't care, I want my overage. And I'm not prepared to accept any situation where I don't get my overage. Whereupon the bank will say, well, you know, it's like a rock and a hard place. We won't lend the money unless you agree that your overage is postponed until after our mortgage. So the deal won't go ahead. So this sort of discussion needs to be had right at the beginning about whether the builder has got a bank and whether the bank is happy with the overage, and whether or not possibly the only solution is that the bank agree that although their mortgage will have priority to the overage, they agree that if they sell the land, which they will obviously want to do, if they've repossessed it, whoever they sell the land to will agree a direct covenant with the original seller, the farmer, for example, saying that the new owner will pay the overage in the same way, because the land may not have been developed by that stage and it may still be a field. So this kind of stuff is really difficult to get sorted out in principle. And people will just sort of shout and argue and say, well, we're not doing this. And you have to say, look, this has to be a practical solution. And the practical solution is normally that the seller agrees that the bank's charge has priority, the builder's charge has priority, and that on basis that when they repossess and sell, if they repossess and sell, which they might never do, then they will only sell it to someone who agrees to pay the seller the overage on the same trigger events when it's finally disposed. I hope you followed all that. It is hard. You might need to have a lie down and then look at it again. But it is something that I used to argue about all the time when I was acting for banks over priority, because I didn't want to find that the bank would repossess the bank, have to pay all this overage out, wouldn't be able to pay all the mortgage off, and then say, you advise us on this, your firm's got to pay it all off. So some banks are prepared to accept restrictions, some aren't, but do get it clear. And obviously, it's something that surveyors won't be aware of and it won't appear in the heads of terms. So sometimes you have to have a word with the conveyancer on the other side and say, how are we going to get around this? What's the issue here? And sometimes I'll have to say, well, before anyone drafts anything at all, let's get these sort of points of principle agreed, so then we can start drafting it. It's no use just sending me a standard PLC overage provision, because it doesn't apply. If you're buying stuff from, say, a public authority like, I don't know, Commission for New Towns or Treasury Solicitor or a local authority, they will normally have a standard form of overage agreement that the Treasury have approved, which they will use, and you'll just have to accept it. But they may be able to tinker around with it. Another way of reserving overage is a ransom strip, but that's very dangerous, because there have been cases where the ransom strip is circumvented, or the buyer gets adverse possession to it, and then you lose your overage. Or it could be that there's a ransom of the ransom. Now, this one might be a bit of a hard issue there, whereas this buyer sells on the land to another buyer, but they retain a further ransom strip. So the ransom strip ransoms the ransom, and then the original seller only gets half the ransom, and the second owner gets half the ransom. Bit of a head wrencher, but just don't do it, basically. Sometimes people reserve rights of way as a ransom, or right of way over it, or they grant an easement over a ransom strip, which only restricts the use to particular uses. All of these things have got problems, and it may be appropriate in the circumstances, but as I say, the most common way of dealing with it is just to have a straightforward positive obligation, carefully drafted, with a restriction appropriately drafted to protect the parties. So yeah, overage gain before you draft anything at all, as I mentioned on page 30, key points to understand are how long is the overage for? Often 10, 15 years, no longer, maybe only 5 years. Obviously, the longer it's tied down, the less the seller is going to like that. You're not going to get overage 30 years later. It's just going to be impossible. Often, sellers, surveyors put it in as a knee-jerk reaction because they don't want any risk. They've been criticised for selling it for too long. Secondly, who's going to police the overage acting for the seller to check what the builder is doing? Does the seller understand that you are not going to be advising on the financial aspects such as valuation or any indices or accounting advice on deductible expenditures or capital gains tax or anything of that nature? And they will have to pay their own consultants on that. Next, is there a lender involved on either side, and how is this going to be agreed? Next thing, how many bites of the cherry? Is it a one bite of the cherry, which is dangerous for a seller, means that the buyer might be able to circumvent paying the overage altogether, or is there going to be multiple bites of the cherry, which is what most of the precedents say? Then the most tricky one of the lot is, when is the trigger events? So is it payable on the grant of planning permission? But it could be that the builder hasn't got any cash because it's going to be 2 years before it gets sold. Or is it valued on the point of disposal, in which case the money will be there to pay it? And the grant of planning permission can be problematic. There was one case where the seller's solicitor thought, when they said grant of planning permission, they meant the approval of reserved matters. But the builder pointed out that there is only one grant of planning permission, and that was the grant of the outline permission, which was, sorry, the sellers pointed out that, not the builders, get it around the wrong way. The sellers said it's the grant of the reserved matters 2 years later, after the grant of the outline permission. The buyer said, no, there is only one grant of a planning permission. That's the original one, 2 years before, and the land was worth £500,000 less. So what planning permission are we talking about? Are we talking about outline? Are we talking about any planning permission? Are we talking about approval of reserved matters? Then are we talking about the date of implementation of a planning permission, which might be later? Are we talking about permitted development rights? Because lots of things can be done now without planning permission. And if it's only the grant of a planning permission, you won't get any overage. If it's any approval or permitted development rights, then you will. Or is it simply a change of use or anything else of that nature? So you need to talk to a valuer and your client about what is going to be the trigger event. I'll give you an example of things that got wrong. I had a client who came in, he'd agreed overage on the basis that they paid £25,000 per house, and they were intending to build 4 houses, so he'd have to pay £100,000. A couple of years later, he came in and said, look, I've got round it. What I've done, instead of going for 4 houses, I've gone for a block of 10 flats. So that way I won't pay any overage, because it was only payable on the sale of houses. So I got the documents out and I said, I've got bad news for you. It says for £25,000 on the sale of any dwelling. And he said, what's the difference? I said, well, it's a flat is a dwelling. So you've now increased the amount of overage you paid. He said, no, I don't agree. I think it says houses. No, look, it says dwellings. Oh, well, a flat isn't a dwelling. I said, I'm afraid a flat is a dwelling. So you should have talked to us before you went and got the planning permission. So think very carefully about definition of disposal, lease, transfer, change of use, occupation, etc., to make sure that you know when it's going to be triggered. And works or change of use or deemed implementation. And then is there any obligation on the buyer to actually make any planning obligation? Not usually. Otherwise, it gets really more into like conditional contract type territory, and you ought to do it that way. Otherwise, the builder doesn't have to do anything, and if say an option period, an overage period of 5 years, they'll just wait for the end of the 5 years, and then they'll make the application, and the seller won't get any money. If you're worried about that, then go down the conditional contract route. Will the buyer actually have the money to pay it when it's due? Is it going to be intention that the builder, the buyer, will sell it off in bits, branches, houses, plots, phases? And it may be that you thought as the seller he's going to sell it all in one go, and it may be that you haven't drafted in the overage how this is going to work when there's a sale off of part, because you may have to do new calculations and further calculations each time there is another sale with another trigger event, with the price going up each time. So it can be really complicated in these situations. And again, look at precedents, look at Gavin Lashat's book, talk to people, think of a structure. It's bespoke drafting. What things will not trigger overage? So you see, you may have an obligation under a planning agreement to, say, transfer land for open space. Well, you'll say, well, I'm not going to trigger overage on that. That's a permitted one. You have to give us a removal of the restriction for things like that, drafted in the restriction or drafted in the document for permitted developments, open space, social housing, infrastructure agreements, substation leases, and things of that nature. And then what happens if you're, say, dealing with a house builder where the house builder accepts a part exchange property? How is that calculated in it? What about the house builder sells the houses on, he knows there's overage, but he, say, offers incentives like paying SDLT or perhaps extra kitchen units or improvements. He'll want to deduct those sort of incentives because it's cost him money to procure the sale. Is that dealt with? And what about, as I said before, potential successors to the builder or the buyer? What happens if, for some reason, after 2 years down the 5-year option overage period, the builder buyer wants to sell it? Is there something in there saying that they will be allowed to do so? And normally they will say that they should be allowed to do so, and that you will agree to release the restriction, but only on condition that the new buyer enters into a new deed of overage with you, the original seller, saying that you're stepping in the shoes of the builder and you will be bound by all the same provisions of the overage the same way as the original buyer or builder was. So lots of things of that nature. Just like we talked about before on calculation of price for overage, you've got to think conditional contracts, you've got to think about the numbers. What is the base value? The buyer stroke builder shouldn't have to pay overage on the general increase in value of land, like I've said. So there'd normally be a valuation immediately before the trigger event. In theory, the value would be able to say what would be the price of the land without the trigger event, what would be the price of the land with the trigger event. That's the increase in value. That's what actually attracts the overage there. And again, there will be provisions about parties able to agree it. If they can't agree it, then it goes to a surveyor as an expert to assess it. by reference to the rules and procedures set out in the overage agreement itself. On page 34, we've got a number of other little wrinkles talking about sales of part. And if you've got a sale of part, let's say you've got, let's say the builders had £300,000 worth of costs that they've agreed can be deducted before the overage is paid. And they sell off the first house for £250,000 of the plots. And they'll say, well, look, you know, you're not getting any money, Mr. Seller, because we've taken the first £300,000 to pay our costs. And they'll say, well, that's not fair. You know, you're selling 10 houses. So really, you should only knock off £30,000 off the valuation for calculation of overage purposes off the first house, and then drip feed it through as it goes on, because I want some money. And if you haven't thought about the mechanics of how it is actually going to be paid off, the overage in each case, it can end up with arguments and disputes. So it may be that you have to say that there's a calculated calculation that says that on the sale of each tranche, a proportion of the builder's costs will be set against the calculation of the overage. And also the builder otherwise might just lose interest and not build anymore once he's got enough profit out of it if he thinks you're getting all the money. So what happens if the buyer decides to not actually sell the houses and he wants to rent them out on assured short hold tenancies? There'll be no money for the seller at all. And he might do that till the end of the 5 years and then sell them. You know, have you thought about that? What if the seller finds the builder occupies it for their own purposes? They build an office building, which the seller thinks they're going to build and then sell on. And as happened near where I live, the builder actually just moved into it themselves and then sold their existing building they didn't have to pay any overage on. And they said, "Ta-ra, you're not getting any money, Mr. Seller," because the trigger event was only disposal of the land. It didn't have a trigger event of implementation of planning permission or a trigger event of occupation or use of the land, which would have meant that the overage was payable. What happens if the builder tries to sell it to somebody else, a mate of his, for less money, you know, or a nominee, or sets up another company? How are you going to make sure that there's no sort of collusion, or there's going to be anti-avoidance type provisions in there? What if they sell the shares in the company, like I said there? So there isn't a standard provision. Do have a look at practical law, look at Nishat's books at that to see how you can work your way around those. And then, as I said before, think about, as I mentioned on page 35, the issue of the certificate to release the restriction that is going to be acceptable to both the buyer and the seller. You might also want to try and draft in some good faith provisions, such as if you've got something like that, it becomes more of a partnership agreement, and you might have to put some obligation in there saying that the builder will act in utmost good faith, or will agrees to use their best endeavours to increase to sell the properties for the best price reasonably obtainable, and things of that nature. So you can try and make sure that they don't get involved in any kind of ruses to try and avoid paying it. And affordable housing is an issue there, because it may well be that the builder has to give the land away or sells the land for a cheap price to a housing association. The seller might have to accept that they don't get any overage at all on the affordable housing element, because basically it's not really being done for profit. Or similarly, permitted disposals. The buyer will want to make sure that there's no overage triggered on transfer of land pursuant to Section 106 agreements, transfer of lands to the local highways authority, provision of substation leases, things of that nature, the grant of licenses or short tenancies, the grant of easements, or disposals of open space to the local authority. Also, the buyer will want to exclude from the definition of disposal the grant of a mortgage that the builder will have to enter into to get the finance, to perhaps development finance, to build out the land. And then what happens when the development is finally complete? If the trigger event is completion of the development, then the builder might deliberately not complete the development, not triggering the overage. Who certifies completion of the development? What happens if the building is never brought into use? And that sort of thing can be quite problematic there. What was I going to say? Dispute resolution is a necessary thing, because there will always be cases where the buyer and seller do not agree on points, and either they end up going to court, or there is some sort of dispute resolution procedure such as ADR or mediation or something of that nature. The advantage of court is that you can go to court more or less immediately for injunctions. Trouble is it's adversarial. Ultimate hearing might be 2 or 3 years down the road, and it ends up quite expensive. Arbitration has the advantage of privacy. You don't wash your dirty washing in public, and it's an established system. The disadvantage is you haven't got the ability to sort of subpoena people like you have in courts to make them come along and to give evidence. Usually experts or mediation are what people go down the route of. So you might use an expert to resolve disputes in relation to the calculation of money or financial issues, and you might use mediation for things relating to the interpretation of the document, is perhaps another way of doing it. But a lot of the disputes are going to be over money and deductions from value. So exactly the same as I mentioned before in relation to conditional contracts, you need to think very carefully of the way in which the overage is going to be paid. Normally, there will be some sort of valuation that the builder will have prepared already to calculate what they're going to make out of it, and showing the residual value of the site. And if the word residual valuation is a surveying term, so surveyors are quite used to doing that, to work out what the value of the site is after deducting developers' costs, planning permission contributions under Section 106, community infrastructure levy, general infrastructure costs, highway improvements, cost of sales, financing and fees. And then you will use that to work out what the profit element is, and then perhaps a percentage of that will be payable as overall. But it really, everything is up for grabs here, and it's important to get this understood at the heads of terms side of it, really. If there are site assembly deals, you've got the same sort of problem of averaging the cost across the whole of the development. And also be warned that sometimes these things can be quite harsh. And the case of London and Ilford is an example, recent case, where a developer was required to pay an overage sum if prior approval was obtained to convert office space to 60 residential units under permitted development rights. Okay, so the builder successfully got prior approval, but unfortunately, as is often the case of conversion from office to residential, it wasn't possible to actually do the conversion because it wouldn't be possible to comply with building regulations. The builder then said, well, I can't actually do it because I'm not going to make any money because I can't get building regulations approval. And the court said, no, the trigger was getting prior approval. So they had to pay the overage, even though it was a completely worthless prior approval and they couldn't sell it. There is no consumer rights. There is no, it's not fair. They had to pay it. So always expect sort of problems of this nature. Expect the unexpected. Expect, although there is goodwill on the buyer and the seller at the time of the entering into the agreement, in 2 or 3 years' time, the builder will be doing everything he can to avoid paying the overage. And they will look through whatever you've drafted with a fine tooth comb to see if there is a way out. And they've got months and years to devise strategies of not paying the overage. And of course, you're in the frame because they will be relying upon you as the solicitor to make sure they get the money, and they'll be relying upon you, the builder's solicitor, to find a way of not paying it. And they'll blame either of you depending on what happens. And they're very quick. So always, if you've got anything complicated like this, always run it past somebody else. Always ask someone who's experienced in this to say, look, how would you have worded this? Can you see a problem putting your evil hat on of a way of getting around this overage? The next thing, of course, is the horror of valuations and maths, and the need for perhaps worked examples so that in the case of dispute, there can be something you can look at. And then finally, to add a headache to a headache, stamp duty land tax, which people get wrong all the time. If any part of the consideration is contingent on something happening, tax is payable on the assumption that that happens and the money will be payable. So in other words, Section 51 says, in effect, that if you have to pay overage in the future, let's say you're buying the land for £1 million, and if planning permission is granted, then you have to pay 50% of the increase in value. And the increase in value would be to £2 million. The way the Finance Act is drafted is that you, the taxpayer, purchaser, has to make a self-assessment of what that overage might be on the assumption it does get planning permission, and pay tax now on money that you may never pay. So you then have to pay SDLT on £1.5 million, even though you're only paying £1 million now. And I can hear you saying, we never do that. Nobody's ever done that. I'm sorry, that's what it has always said for the last 20 years. And it's because HMRC are rubbish at enforcing it that it hasn't become apparent. But the risk is that if they do serve a notice on your client saying you needed to pay some extra money, then you will be negligent for not having applied for deferment. Because what Section 51 says, that this is subject to Section 80 and Section 90, that says that if you've got a situation where future additional consideration is payable, it's possible to make an application for deferment, postponement of payment until this thing happens. And I've got further details we'll come on to on how you do this. And it's very important that you do this. And I've seen so many people saying, oh, well, I'm going to make a self-assessment that is only a 10% chance of it happening. So I'm going to assess it as being 10% of £1 million. That's not what the section says. The section says you have to assume it will happen. So therefore, what would be the value? And the idea is that, let's say it was £1 million going up to £2 million, and with a 50% overage, you would pay the tax on the £1.5 million, but then when you did pay it, you would pay a refund or extra depending on what the figure was. Now, if you look at page of my notes, I've got detailed provisions on page 43 of how you make that application and what you have to do. And the example there on page 43 gives you an example of a developer finds 5 years down the line he has to pay £1 million overage and you didn't apply for deferment. You'd have to pay interest at 3% compounded on that for 5 years of £150,000. Whereas if you'd made the application for deferment, you wouldn't pay any interest and you'd only pay it from the date it was due. So I warn you, you need to make application for postponement or deferment in the case of any overage that might be payable on purchases. And then finally, just a couple of words before we finish, on land promotion agreements. Now, what I've been talking about you for the last almost 3 hours is a horror story of aggression and animosity between buyers and sellers, each trying to get over each other. So this is where the land promotion agreement comes into play, because as I said right at the beginning, it's more of a partnership agreement whereby the buyer and seller agree that they will work together to appoint consultants to make a planning application using the developer's consultants. with the developer paying for all of this at the outset, but agreeing everything with the seller. And then when a planning permission is obtained that they all agree, then the builder will try and sell it using their consultants and expense and experience. And then ultimately, when a buyer is found, the seller will sell it to the buyer that the builder has found, and they will share the booty, giving the builder a refund of all his costs and giving him perhaps 50% of the profit made. Obviously, the risk for the builder is he's going to put out a lot of money and he might never get planning permission. But the booty is that he might get a great increase in the value, and he doesn't have to proceed if he can see that they both agree that it's a wasted effort. So land promotion agreements are more of a partnership agreement. And again, the same things have to be dealt with in relation to the development. But what will happen is that the parties will meet each time and agree each step. And so it's a much more amicable way of dealing with it that may be appropriate for the circumstances. So I hope you found this very interesting and not too terrifying, but it is the best sort of work you can ever deal with in a commercial property office, trust me. But it isn't something you leap into and assume it's just a question of a process and standard documents. Get Mr. Catt's book, read my notes carefully, look at the precedents, and good luck. If you've got any questions, by all means, either switch on your microphone and talk to me or type something in the chat room. And I hope you'll get the notes and the 3 examples of documents to read in your leisure. Any questions? Thank you, Gillian. I'm glad you enjoyed it. No, it's an area of work which I really like. That's because I like to live dangerously. Okay, well, if that's all, I will sign off, Catherine. If you can hear me, I'm going. Go and get a cup of tea and a lie down. Bye.